Good morning, everybody. Well, here we are for another day's webinar with AstenJ, and we've got quite an interesting mix for you, I think, including a very topical update on the progress of the illegal migration bill, which is just coming back to the House of Commons after its third reading in the House of Lords. And there are amendments aplenty proposed by the government. We'll be hearing all about that this afternoon, but I'm afraid you're stuck with me to begin with. Now, I'm going to try and get everybody to stick to our timetable, and we're actually proposing to end at a reasonably early time, 4:30. So if we can get through everything by 4:30, I'm sure you'll be relieved to get away and relax, because there's an awful lot to take in during the day. Perhaps not so much with the first talk, which is by me, and it's entitled Visiting the UK. Now, you'll have got my course notes, and I don't propose going through them. That would be a bit boring. You can read those course notes at your leisure. So I just want to highlight a few things from the course notes and focus on them. And first of all, there's the distinction between visa nationals and non-visa nationals. So if you're the former, you have to get a visa before you travel to the UK. If the latter, you don't. You can just turn up at the port of entry with your passport. Now, there used to be an awful lot more non-visa nationals than there are now. Commonwealth countries, citizens of Commonwealth countries did not need a visa for a visit to the UK until I think 1986, when the Tamil insurgency in Sri Lanka had begun in earnest, and a lot of Tamils were arriving in the UK from Sri Lanka and coming in without a visa and then claiming asylum. So that led to the first imposition of visas upon a Commonwealth country. And gradually it was extended on a country by country basis, depending on the number of people who came from that country without a visa and claimed asylum. So, for example, in 1995, I recall, as I was working for the Immigration Advisory Service then, a lot of people started landing at Heathrow on flights from Dar es Salaam. They turned out to be members of the Civic United Front, a movement in Zanzibar, which they said was being persecuted, and they were claiming asylum. So a visa requirement was slapped on Tanzania. So coming up to the present day, we have quite a complicated mixture of requirements for people who are not visa nationals. So, for example, if you belong to one of the more prosperous countries in the world, the United States, Canada, Australia, New Zealand, Japan, South Korea, Singapore, and any of the member states of the European Union or the European Free Trade Area, they can get in simply with their passport and swipe it at an electronic gate, an e-gate, at the port of entry. Then they don't even need to see an immigration officer because they will be automatically registered as having been given leave to enter the United Kingdom. The old-fashioned way of doing it would be to present your passport at the port of entry and get it stamped by an immigration officer to show that you've been given leave to enter for usually 6 months. But with the e-gate, you just walk through and you don't have to see anybody. The only problem might be proving your right to be in the UK. If anybody asks you to show your document that you've got leave to enter, it's in your phone and you have to show them from that. Now, it's not just those wealthy Western or Westernized countries that have a privileged position as regards entry to the UK. Also, the wealthy Gulf states, which are not Westernized except in respect of being wealthy, I suppose, they're also given privileged treatment, because although they are currently all visa national countries, their citizens can come to the UK without needing a visa by what's called the electronic visa waiver scheme. And this is open to citizens of the Gulf Cooperation Council, Saudi Arabia and the Gulf states, as well as, and then also Jordan. So they can come in without a visa at the moment. And there are also arrangements for citizens of other countries who are transiting through the UK, but they're going to or from a number of reliable countries like the United States, Canada, the member states of the European Union. And those people can get what's called a transit without, they can register for the transit without visa scheme. So it's restricted to passengers traveling to or from Canada, Australia, New Zealand, or the United States, if they have a valid visa for one of those countries. And also if they actually have a right of residence in one of those countries or any of the member states of the EEA, they can be excused a transit visa for transiting the UK. Anyway, that's all a little bit complicated, but the basic distinction between visa nationals and non-visa nationals is still currently predominant. So I'll return to non-visa nationals in a bit, but let's talk about visa nationals, because by far the largest proportion of countries in the world are visa national countries. And so their citizens do need a visa before they come here for any reason. For some years now, the application for a visa has to be made online. And then an appointment, once that form has been submitted electronically to the Home Office, then the documents needed to back up the application have to be transmitted themselves electronically. But you can do it yourself or get your representative to do it. But of course, you can also get the staff at the Visa Application Center to scan and upload the documents to the Home Office for you. Now, there's still plenty of work for lawyers helping people to make visa applications online and to get the necessary documents together to back up the application. So particularly for family visits by parents, siblings, and what have you, very often sponsors will come to a solicitor's firm and ask for help in getting the visa application made. They're worried that, particularly from certain countries in what used to be called the third world, the failure rate for applications is very high. So they're worried about their application being refused, or it should be their relatives' application for a visa being refused. Now, I'm sure a lot of you have got experience of helping with visa applications. So you'll know all about filling in the form electronically and then printing off the checklist of documents that you're going to be submitting to the Home Office, and then making an application with the Visa Application Center abroad. In Africa, the company that runs the visa application centers is TLS Contact, and in South Asia and other parts of the world, it's Visa Facilitation Services Global, VFS, but they run very similar systems. So you pay a fee to make an appointment for your biometrics to be taken. And then if you want extra services, you can pay for them. So for example, TLS offers 2 services for which you pay an extra 87 or 89 pounds, or the equivalent in dollars. And one is for a service where instead of being given a particular time of day for your appointment at the VAC, you can come anytime on that day. And then there's another service where you can choose a much sort of wider period in which you can turn up. So, and then also, and this I think makes life a lot easier, you can get the staff to scan and upload your documents for you. And that only costs £28. So it's worth doing, I think. It's not a lot of extra money to pay. And then you wait for the Home Office, once it's received all those documents, to make a decision. Well, there's more work for lawyers once the decision has been made, because it's very often negative. So you might well be asked, what can we do now? Can we appeal? Unfortunately, you can't. There is no right of appeal for visitors if their application for a visit visa is refused. Now, there used to be, years ago, a right of appeal to what used to be called immigration adjudicators, and later on to the Immigration Tribunal. But the right of appeal, after going through various vicissitudes, eventually was abolished altogether in 2013. Much to the disappointment of immigration judges, I might say, as well as to people applying for visit visas, because family visit appeals generated a whole lot of work for the judges, and the success rate of family visit appeals was very high. But as I say, that right of appeal was abolished in 2013. Now, are there any circumstances in which an appeal against a visa refusal might be lodged? Well, it is just about possible. And there was a slew of cases in 2015 centered on the possibility of a visit visa application actually being a human rights application, which would generate a right of appeal. And there are several cases on that, which, if you've got access to Butterworth's Immigration Law Service, if you look at Division 2, that's on visitors, and there's quite a lot of case law on these kind of family visits which potentially involve Article 8. And in fact, some of those are also in your course notes towards the end under the section headed Case Law. You'll notice that some of the cases are just given with the date and not with the usual citation. The reason for that is that those cases were heard by the old Immigration Appeal Tribunal, which was the equivalent of the upper tribunal now. But in those days, all cases that were released by the Immigration Appeal Tribunal, the IAT, were available to the public. So there wasn't a selection made, as there has been for many years. As you know, not all upper tribunal appeals are reported. Only a minority, selected by a committee of the upper tribunal. But in those days, they were all available in paper form, it has to be said. This is back in the 1970s, 1980s, and going right up to the 1990s. Paper determinations, they were called, not decisions, determinations. And the most important ones were given a star to show that they really were important among the plethora of other cases which were all available. So we still today sometimes talk about Deprivation with a star, or Surendran, which was the case about adjudicators entering the arena and taking over the role of the presenting officer, or Tanvir Ahmed, which is about documents which a judge may think is forged, and he doesn't have to say that. He can say instead that the documents are not to be relied on, rather than accusing the appellant of forgery. Okay, so we have these old cases. They were given what was called a bracket number, and it's actually quite hard to find these cases now, but you'll get some of them from Butterworth's, and some actually made it to the Green Books, the immigration appeal reports. So you'll see a couple of the cases there are actually given a full citation, like 1979 immigration appeal reports, or I think we've got another one. Yes, no, we haven't. Nope, we haven't got. Oh, we have. Yeah, we have another one. 1983 immigration appeal reports, the old Green Books, which are still being printed. Okay, so what about family visit appeals then under Article 8? Well, you would have to show that the visit involved a very important family event. And the one case that sticks out was heard by Mr. Justice McCluskey when he was president of the upper tribunal, and it involved a family visit from Pakistan to the UK. The ancient patriarch of the family had died in the UK at a ripe old age, and his daughter and two of his grown-up grandsons wanted to come and join the other family members who were living in the UK to perform the usual obsequies for their grandfather and father. Now, of course, being a Muslim, he was buried straight away after his death. So they were not going to come for his funeral, but they were going to come for, I think it was after 40 days, the commemoration of his death. So they applied for a visit visa. That was refused. In the case of the young men, for the usual reason that young men are liable to overstay and not go back, thinking they can have a better life over here. Anyway, the family took the step of instructing solicitors, and actually those solicitors lodged an appeal on human rights grounds. And although the matter wasn't finally determined by the upper tribunal, having been dismissed initially at the first tier, it was a very long time after the grandfather's death, but it did make the point that this was, in fact, something that could be considered as a human rights claim, because it was such an important event in the life of the family, that to deny some of the family members the opportunity to take part in that event was a breach of Article 8 rights. Now, it would have to be an event of similar importance, like a wedding, or even the birth of a long-awaited child, that could possibly lead to a right of appeal. And it would have to be made clear in the application itself that you were actually making this a human rights claim, not just an ordinary visa application. Okay. Now, what about the great majority of visa refusals where there's no right of appeal, no possibility of turning it into a human rights claim, and there simply is a refusal? Now, there's no right of appeal, nor is there a right to an administrative review. All you can do is make an application for a judicial review. And normally, people are slow to do that because of the expense and the time it takes. The Home Office view, and this was their main justification actually for abolishing visit appeals altogether, is that you're much better off making a fresh application. They only cost £100 at the moment. And so if you make a fresh application, that's only another £100. Whereas if you make a judicial review claim, you're going to end up paying an awful lot more, both for court fees and lawyers' fees. So there was one case which actually I got myself a while back, where the family were adamant that they wanted to seek a judicial review. So I got instructions to write a pre-action protocol letter to the Home Office. And actually, the refusal letter was of very poor quality. The applicant, she was the elderly mother of the sponsor. She had provided good documentary evidence of her income in Pakistan from land which she held. Her late husband's land, she was getting a good rental income from it. And she was also living with another close relative. So those 2 points, were clearly something in her favor, but they were virtually ignored by the ECO when he decided that he was not satisfied that the applicant would be a genuine visitor and would leave the United Kingdom at the end of her visit. So anyway, I pointed out the frailties in the refusal letter, the way that material evidence had not been considered, and put this in the pre-action protocol letter. And that had the satisfactory outcome that the Home Office wrote back and said that they were withdrawing their decision. The application would now be reconsidered, and therefore would we withdraw our claim, which of course we did. So after some considerable time, the decision on the application came back, and this time they'd done a much better hatchet job on the application. They still refused it, but they gave better reasons. So it turned out to be something of a Pyrrhic victory. And it's really very frustrating for people in this country who do have close relatives in the subcontinent or in West Africa, places like that, where the refusal rate for visitors is very high. But there it is. Well, I said that I would go back to people who are non-visa nationals and see what the future holds for them. Now, a big change is underway. Up until now, non-visa nationals simply had the option that they could turn up at the port of entry with their passport and seek leave to enter from an immigration officer. Very easy. And there was always the option of getting a visa anyway to avoid any disappointment on arrival, because of course it could happen that you would arrive in the UK confident that you would be allowed in and then be told that you wouldn't be because of maybe something that was discovered in your luggage, or you hadn't given a very coherent explanation of why you wanted to visit the UK and what you were going to do. So that could lead to your entry being refused at the port. And you would have no remedy except for judicial review against being sent back straight away to your own country. The most you might get would be what used to be called temporary admission, if you were going to be allowed to come in for a day or two to see relatives or to do some business. But that was taking a risk, of course, because the person could have abscond, so it wasn't so easy to get temporary admission. Now, of course, it's called immigration bail. So if you're refused at the port, you're likely not to get in at all and be sent back to your own country, unless you lodge an emergency application for the removal directions to be deferred. Well, what is coming in now is a scheme whereby you will have to seek some kind of pre-arrival authorization before you get to the UK as a visitor from a non-visa national country. And this is called an ETA, okay? And you'll be able to read more about that towards the end of the course notes about the electronic travel authorization, which is coming in quite shortly, in fact. The first country to be eligible for ETAs, electronic travel authorizations, will be the Gulf state of Qatar in October. And then it's going to be extended next year in February to the other member states of the Gulf Cooperation Council and Jordan. So instead of paying, as they now do, £30 for an electronic visa waiver, this is for nationals of the Gulf Cooperation Council states, £30 for an electronic visa waiver, and for Jordan, £100, because this is what they have to pay for an actual visit visa. They're actually not eligible for the electronic visa waiver. Sorry about that. It's only the Gulf Cooperation Council. So Jordanians currently pay £100 for an ordinary visit visa, but citizens of all those countries will, by February next year, be able instead, for a payment of only £10, to get an electronic travel authorization. Now, that is not leave to enter. It's not a visa, but it simply indicates that your entry has been approved, because based upon your nationality and your answer to a few simple questions when you apply for the ETA, there is no reason to suppose that you would not be a genuine visitor. Aha, you say, hang on a bit. Isn't this for non-visa nationals? And aren't these countries visa national countries? Well, they are, but they won't be for much longer. So those wealthy Arab states will become non-visa national states, and their citizens will be eligible for the electronic travel authorization. And then when they arrive, they will simply swipe their passports at an electronic gate, and their leave to enter will be automatically registered. The ETA will be linked electronically to their passport. So it will be obvious to the AI machine, whatever it is, when they swipe their passport at the e-gate, that they've already received approval from the electronic travel authorization. So in they go with leave to enter. What can possibly go wrong electronically? we'll see. Now, this ETA will also have to be applied for by people from countries which traditionally have never needed to get a visa to come to the UK. So Canada, Australia, New Zealand, those old Commonwealth countries, the United States, Japan, South Korea, wealthy East Asian countries, they, well, certainly in recent times, they've never needed a visa, and the old Commonwealth countries have never needed a visa at all. So they will have to get electronic travel authorizations. So it only costs £10 and it's valid for 2 years. So it's not a huge imposition, I suppose. And the idea is that to secure our borders, the government wants to ensure that nobody gets in without some kind of pre-arrival scrutiny of them, their identity, and anything that might be something that would give cause for concern if an investigation reveals that they are not admissible because of their character, conduct, or associations, something like that, to be a sort of pre-entry scrutiny before they can get their electronic travel authorizations. So there might be a question to do with, if they've had a criminal conviction, that sort of thing, which could cause a problem for getting an ETA. Okay. Now, does anybody have a question so far? I think there is one in the Q&A, if I can just have a look at that. Oh, can we have a precedent pre-action protocol letter for JR? Oh, well, actually, I don't use precedents myself. I just write a letter just depending, on the client and the case itself. I don't really believe in precedents, though. Some people find them time-saving. But I think that's the only question so far. Don't be shy if you have any. Here's another thing that not many people know about visitors. It's not to do with getting a visa, but once you're in the UK as a visitor, you can't switch to anything else. So if you form a relationship with a British or settled person during the course of your 6-month visit, and you want to stay on the basis of that relationship, well, you have to go back and to your own country and get a visa to return. You can't switch. Okay, so you simply can't switch. Now, I've got a case pending where a husband came to join his wife. He got a visit visa to do so. She's actually a British citizen, resident in the UK. So he came on a visit visa, and he applied during the currency of his leave to enter for leave to remain as a spouse. Now, he was refused, but not on the basis that he couldn't switch. He was refused on the basis that there were no insurmountable obstacles to him and his wife continuing their family life together in their own country. She was from the same country as him. Now, in fact, the Home Office mistakenly thought that Appendix E, EX1B, that's the one for couples, EX1B, applied to this case. And therefore they could refuse on the basis that there were no insurmountable obstacles. But in fact, EX.1 doesn't apply at all to visitors. If they try to switch, if you actually read Appendix FM, I think it's ELTRP, yes, ELTRP, point 2.2a, something like that. It says that that's not possible. You can't rely on EX.1. Yes, I'm afraid we are still stuck with the amazingly complex numerical system adopted for Appendix FM. And I think it's interesting that the Home Office team, which for a long time now has been supposedly simplifying the immigration rules, has never got round to simplifying Appendix FM. You may be wondering why all these new appendices keep appearing at the end of the ordinary immigration rules, so that in fact the appendices now greatly outnumber the ordinary immigration rules, you know, part 1, 2, 3, and so on. Well, in fact, part 2 and 3 have gone just about. Anyway, that they outnumber all the ones in the sort of early part of the rules. That's because the team at the Home Office that's reforming the immigration rules has been trawling through all the more simple ones, as it were. And it's called the SORT team, Simplification of the Rules team. So far, they've stayed away from Appendix FM and, again, not surprisingly, Appendix EU, which of course is even more complicated than Appendix FM. Will that ever be simplified? Maybe as lawyers, we shouldn't be that keen on simplification, because if the general public is completely baffled by Appendix FM and Appendix EU, they have to come to lawyers. So it's an ill wind. Anyway, that case about the husband, I don't think I'll mention this because it might tangentially be interesting, because we've got some talks today about nationality and deprivation of British nationality, and this case involves British nationality conferred upon the inhabitants of the Chagos Islands, also known as the British Indian Ocean Territory. It still is the British Indian Ocean Territory, and whether the husband, who's a visitor, might be able to benefit from the fact that his spouse is a Chagosian. So the Chagosians were expelled from their islands by the British in the late 60s, and they had to settle in Mauritius, where they lived in poverty and they were discriminated against. So they were in a very unpleasant situation. Attempts have been made over the years to remedy their situation, but it's only in quite recent times that the government has acknowledged that they were badly treated and has now enabled them, and this is in the Nationality and Borders Act 2022, the government has now passed legislation to enable Chagosians to register as British Overseas Territory citizens and indeed as full British citizens if they have a parent or grandparent who was born in the British Ocean Territory. Okay, so that's all well and good, but somebody who's not a Chagosian, can he take advantage of the fact that his spouse is a Chagosian? And the argument, which may possibly succeed, is that it's akin to the historical injustice which was inflicted upon the Gurkhas. You'll remember quite a few years ago now, there was a lot of publicity about a court case that was going through about whether the now grown-up children of Gurkhas should be allowed to settle in the UK with their now elderly parents who were veterans of the Gurkha Brigade, on the basis that if the Gurkhas on discharge from the British Army had been allowed, as they now are, to settle in the UK, those children would have been admissible when they were minors and could themselves have become British, instead of now being adults and not being eligible to come and settle in the UK. Joanna Lumley, the actress, played a big part in publicising this, what the Home Office eventually recognised was an historical injustice, given the assistance which the Gurkha Brigade had given to this country. So overage children were admitted. Could it be that husbands who don't have entry clearance as a spouse could be allowed to stay even though they didn't come in through the right means? Perhaps rather unlikely, but we'll see. Now, what does the future hold for visitors? Are we ever likely to see a right of appeal being restored? I think that is very unlikely. We will be left with the possible remedy of judicial review. And even if you scare off the Home Office by writing a very good pre-action protocol letter and the decision is reviewed, there's a culture, I'm afraid, among entry clearance officers that they do like to refuse, particularly applicants from certain countries. And although you'll see in the case law section of the course notes, going back many years to the old days of the Immigration Appeal Tribunal, which said things like, oh, just because the applicant is a young man from a poor country, it doesn't mean that he's not going to leave the UK after his visit. Or just because somebody has even expressed a wish at interview, this was in the days when applicants were actually interviewed by entry clearance officers overseas, they might have expressed a wish to settle in the UK if that were possible, but that doesn't mean that they're going to breach the conditions of their leave to enter if they are admitted to the UK as visitors. So things like that should be settled law, but they're still being used as reasons for refusing visas. You know, a young person, not enough connections to his own country to satisfy the entry clearance officer. He will be told that he's not a genuine visitor and he's intending to stay after the end of his visit. Oh, now let me just have a look at the questions and answers and the chat. If I can just get my cursor in the right place. Here we are. When it goes to judicial review, what do you think the material legal test would be that the applicant needs to satisfy? Well, the test is in the immigration rules themselves. In order to be a genuine visitor, you must intend to leave the United Kingdom at the end of your visit. And there must be in place satisfactory arrangements for your maintenance and accommodation. So if you have a sponsor who's willing to pay all your expenses and to give you board and lodging, you know, that will be part of your application. On the other hand, if you are going to be paying for it yourself, then you will have to show that you have enough money in the bank and you have income coming in. Now, actually, when you're making the application, you should be sure to provide documentary evidence of an incentive to return to your own country. So if you have a regular job paying a monthly salary, you should provide 6 months worth of bank statements and payslips just to show that you have a job to return to and it pays you enough to give you a decent livelihood in your own country. So then it's harder to argue that you've come to the UK as an economic migrant and you're going to stay here and look for work. Another incentive would be close relatives in your own country, preferably living in the same house with you or very close, so that you have a family life or, you know, close family ties at least in your own country, and you're not going to be forming a closer family tie in this country. Now, in the case of parents who are coming to visit children, it could be said by the ECO that they're going to be looked after now by their own child. It's a tradition in your culture, you know, that let's say the eldest son looks after his elderly parents. You're an elderly parent and you're going to visit your eldest son. That sort of thing could be used to show that you are not going to go home after the visit. So that's really the sort of thing that you have to bear in mind when making the application, to back it up with documents showing that you've got a good life in your own country and that you have an incentive to return there. Now we've got another question, which I think might be, oh no, this is different. Are you dealing with grounds for refusal? If yes, how can one defend use of previous false documents in a previous application? Well, I'll be saying a bit about this in my next talk, the Brexit, what have I called it? Brexit bafflement. Anyway, there is a section in that about what used to be called the general grounds for refusal, which include production of a false document in a previous application with a view to getting that application. Now, this can lead to a mandatory refusal. But let's wait till the next talk and I'll be coming back to that and we can talk a bit more about it. Okay, now I'll go on to the chat and see what comes up there. Oh, no, Samar Khan raised his hand. Oh, ask him to use Q&A. Right. So let's just go back to the questions and answers. Now, that gentleman hasn't yet put a question into the Q&A box, but please do. And I think there'll be time, just about enough time before the end of my talk to answer the question. And here it comes. Oh, thanks. Okay, well, do type in the question and hopefully I'll be able to answer it. I think there are more questions. Sorry, I haven't come around to the end. Oh, here we are. What documents are needed for elderly parents applying to visit the UK in respect of their financial situation in their country of origin? Well, documentary evidence of their income. Do they have a regular income at all? So, for example, do they receive rental income from property which they own? Or are they in receipt of a pension? Are they in receipt of regular remittances from relatives abroad? So all of these things can show that they have an adequate or even quite a good standard of living in their own country. So financially they're secure and they don't have a great financial incentive to stay in the UK. So you do need documentary evidence of that. And if you don't have it, the application is likely to be refused. What is the name of the case related to attend a funeral? Okay, I will be able to give you the answer to that. You'll find it in the Butterworth's Immigration Law Service that I was talking about earlier. I'm actually responsible for the visitor section, so I know the case quite well, but I can't quite give you the answer to it straight away. I'll look it up during the break, and I'll tell you after the break. Now, the last question. Oh, it says, I can see and hear you, but it appears I cannot join in. I have sent an email, but no response. Oh, well, I've got your request here. That's come through all right. But I think an email is not the sort of thing that you should be sending. I think you have to type something in the question and answer box, you know, that icon at the bottom of your screen. If you click on that, you'll get a box in which, and in fact, this is what you must have done, you can type a question. So do use that box, and I'll keep a lookout to see if you do send in a question that I can answer. Oh, and I see from the host, we have responded to David, who posed that question. So that's good. Okay, well, I've now reached the witching hour of 10:25, which is when my talk was due to end. And at least I'm going to be on time with finishing my talk. We've got a talk coming up now from Sarah Pinder on the Nationality and Borders Act. And she's bang up to date with her talk because the Nationality and Borders Act is being interfered with by the Illegal Migration Act, bill. So having just come into force last year, it's already being tampered with. Anyway, I'll clock out myself and I'll welcome Sarah Pinder, who is a very regular speaker at these webinars. She's always very interesting and informative. And unlike me, she has very useful slides. So over to you now, Sarah. Thank you very much.
I forgot to bring it down. So yes, good morning, everyone. I'm sorry for the slight hiccup there. I was in the midst of apologizing for my voice. I'm suffering a bit, having had starting a cold at the weekend, but it does sound worse than it is because I am at the tail end of it. As usual, I seem to start these talks with a few caveats. That's the first. The second is also a matter of oversharing. I have my son at home because of a tummy bug that has been added to the mix this weekend as well. So I hope that our connections with his streaming and his activities today is not going to interfere. So if I can just ask that if it does drop out, if someone lets me know, and then Mrs. Shouty will come out and we'll send instructions downstairs. And the third caveat is not personal. So if those amongst you are worried about the oversharing this morning, it is related to the contents and it is related to what Richard said. I am covering an act that does seem to already have kind of been surpassed by further events today. So I have tried to concentrate on the parts that look like they might still be relevant to us. But I hope that it's not useful nonetheless to you, and again that we can all kind of get to grips with that at the same time, because it is all very new. So I'm just going to share my screen, if you just bear with me, and we'll get the slides up and running. So as Richard mentioned, it's Nationality and Borders Act, what's in force, what do we need to worry about? So there's quite a lot that effectively has been brought into force that I'm not concentrating on today. So there are some nationality provisions that's the first part from recollection that I think may have been touched by Joe Byrne in a previous talk last year. But we won't concentrate on that today. There's also quite a lot, there's also quite a lot of the talk today that is not being covered in relation to age assessment. Age assessments have those provisions, some of them anyway, have come into force, but again, they're not fully operational, so we're not concentrating on those. So as I foreshadowed, we're just looking at really what's the most relevant now, and then it may be that we revisit this topic once we know a bit more about the illegal migration bill and when things have bedded down, dare I say it, a bit further. So we're going to look at differential treatment for recognised refugees, but only very quickly because that has already been superseded by a statement from the Immigration Minister earlier last month on the 8th of June, but I still felt it was useful to cover just so that you had an awareness of it. And I think there are some decisions out there granting Group 2 refugees refugee status that still might need resolving. So that's why I've just decided to focus on that, despite effectively that being paused, which we'll look at very shortly. And then the bulk really of the talk is really on the provisions that go to reinterpret the Refugee Convention and what that means. I dare say that I'm quite tentative, I have to say, in how I'm going to present this. It's very new. We haven't seen it in practice yet in terms of responding to cases on refusal or responding to cases on appeal. And really, we haven't yet seen the judges and decisions and what they make of it. So it really is just so that it's on your radar, so that you're mindful of that and perhaps just try and incorporate that into your best practice in terms of how you prepare the claims. And then we'll finish off in terms of how to respond to that and really just highlighting what I've called tools to be mindful of in order to mitigate the potential effects of these provisions seeking to reinterpret the Refugee Convention. But again, it goes back to old tools, really older case law, and the approaches that have been well established for a very long time, if you've been practicing in this area for a long time as well, and also looking at what UNHCR, for example, have said about the Act in the context of them responding to the bill. So they have, I'm pooling from that. So we'll look at that towards the end. So coming back to Group 1 and Group 2 refugees, so that I do try and remain on time for this talk. Effectively, it's a new approach. It was foreshadowed in sort of political statements all the way leading up to that with this government, that effectively those that come directly to the UK, that enter legally, that might be here already legally, for example, as a student, and then for some reason have to claim asylum. So for example, a Sudanese student who's then not able to go back, those sorts of scenarios, then they are very much more favourably perceived and viewed by the government, and so they would come under a Group 1 refugee. And those in contrast that don't come to the UK in such a fashion, so are channel crossers, enter illegally through other means, and might not come directly, so there's effectively two sort of strands to this, might not come directly to the UK, yet claim in the UK as opposed to another quote unquote third safe country. So for those that cross, again, invariably the European continent, are then criticised and fall to be considered under Group 2, and they are the ones that are less favourably viewed by the government. And the consequence of that, effectively in the fourth bullet points just summarised there, is that you've got different protections. So one consequence is that you get a lengthier route to permanent residence. If you're a Group 2 refugee, you might be granted, you might have been granted 2.5 years, and then you needed to seek an extension. Group 1 refugees didn't have to go through that extension. There's also differentiation in relation to family reunion. So Group 1 refugees would not be limited by way of benefiting from the family reunion rules. Group 2 might be so. So there are quite drastic consequences that flow from this distinction. And as I said, it's tied really to just their mode of entry in terms of whether it's illegal or legal, and then really what that travel involved and whether they attempted to claim earlier than the UK with a reasonable opportunity, quote unquote, to do so. Those distinctions, that sort of categorization as to someone who should have claimed in another country, for example, is still subject to without good cause provisions. Those are contained in Section 37 of the Act, with the distinction, the differential treatment, being contained in Section 12. So it's all subject to some power, some discretionary power to consider all of the circumstances. But again, you can guess the approach that was taken, and really the hard line in terms of differentiating in the first place was followed through really in considering that without good cause. In terms of the procedure, so I became aware of the decisions really in around end of April of this year. I've not been at all of those cases related, excuse me, I'm just going to put myself on mute for one moment. Forgive me. When I became aware of the decisions, they all related to decisions having been taken in January. So I'm not aware of cases giving that differential treatment prior to January of 2023. But I may be wrong in that respect. So it'd be interesting to see if anybody else had heard otherwise. It also follows the statement from the Prime Minister in December to effectively prioritise certain nationalities in the claims that were being received in terms of asylum claims. So the sort of high grant nationalities, for example, Afghanistan, Eritrea, Sudan, I think, and there may be some others within that, Syria, and possibly Libya from memory. So that definitely seemed to have been a push, obviously arising from that statement, to then get those decisions out. And the decisions that I have seen all related to those nationalities. So I had an Eritrean client, and then the other was Afghan. Then the notices issued in December in those cases effectively warned of the intention to apply Group 2 refugee status, and that is built into the legislation. So the Secretary of State had to set out that intention and effectively invite rebuttal statements or rebuttal sort of representations as to why Group 2 shouldn't be granted. So that was done in December. Responses were put in, and then quite shortly after, again in both cases, the decision came applying Group 2 status nonetheless. And so those were coming up in January, only challengeable by way of a judicial review, so the pre-action protocol had to be followed, etc. So that sort of started, the gears started to turn, if you like, in terms of practitioners responding to that. And certainly I had a judicial review pending that we'd submitted in May, for then only that to be paused. So it's a bit of a long introduction for something that has been paused, but it has only, in inverted commas, been paused, as in it hasn't been sort of formally abandoned or set to one side in sort of more a permanent way or a more certain manner. And so that you just have in the penultimate bullet point there, the link to the illegal migration update statement is there, which is the statement that effectively out of the blue, as far as we can tell, announced the pausing of this differential treatment. Effectively, what we could glean from that statement was that there seemed to be some acknowledgement that effectively recognizing refugees as group 2 and requiring them to apply for extensions wasn't going to help their backlog and wasn't going to help them abide by their targets in terms of how to process claims and so forth. So pretty obvious, and that was pointed out to them in various consultation responses and so forth, and responses in relation to the bill at the time. But that did seem to be what they were pinning against the decision to pause that differential treatment. I've just spent some time on this, as I mentioned, because I think there are perhaps some decisions that may still need resolving. My judicial review, I'm pleased to say, effectively settled on the basis pre-AOS, with the AOS effectively proposing that this be looked at again, that Group 1 status will be granted, that we get our costs as well. That I was a bit worried about, that they would start messing about, but that I'm pleased from the off that they didn't. And so that's just taking its course, but to my knowledge, that hasn't been confirmed yet by way of a new decision for my client. And of course, there may be some that didn't seek to challenge the judicial review. I know that our judicial review was actually out of time for no fault of the clients, but the pre-action protocol correspondence sort of took over, and that the limitation period was lost in terms of was effectively overlooked. So there may be clients that you come across that have Group 2 status that haven't chosen to challenge that, so therefore that's not been gripped so far, and also it may still be waiting for that to be confirmed. The government has said that persons would be approached to have that resolved, but obviously we all know that it would be best not to wait for the government to do that and to grip that ourselves as well. So that's why I've mentioned it, in case there is some work to be done still from our side as practitioners. So we move on to the bulk of the talk, the bulk of really what's left, what's relevant really to grip within the 2022 Act, which relates to reinterpreting the Refugee Convention. So it is really just an overview that I'm able to provide you. Sections 30 to 35 effectively set the various provisions out that go to, excuse me, that go to effectively redefining Article 1A(2) of the Refugee Convention. So just without telling people how to suck eggs, because I'm very aware that we all know this, but I think again it just helps to remind ourselves and to sort of contrast the provisions. The definition of a refugee under the Refugee Convention is owing to a well-founded fear of being persecuted for reasons of race, etc., is outside their country of nationality and is unable, or owing to such fear is unwilling to avail themselves of the protection of that country, or who, not having a nationality and being outside of the country of his former habitual residence, is unable to do the same. So rather sort of simple, not setting out sort of standards of proof, not setting out how particular matters should be proven and established and assessed. So far, until the 2022 bill, really the UK has applied the Refugee Convention directly. So it's not sought to be codified within the UK's statute book. That is in contrast with other countries that have codified it, that have set that out in their own legislation. So that has allowed effectively the UK in the view of many, including my own, to sort of be leading in the sphere of refugee law, for there to have been all sorts of checks and balances with the common law jurisdiction and the involvement of the courts in seeking to interpret the Refugee Convention and how that should apply over a significant number of decades. And so we're moving away from that. And I think that in itself is really, well, problematic, but also a great shame. The first thing to highlight in terms of these provisions, so they are only applying to claims lodged after the 28th of June of 2022. So this is the date, 28th of June 2022, is when the provisions came into force. And so they can only apply to claims lodged on or after that date. Okay, I've put in brackets in the first bullet point that it includes fresh claims. You will look at the provisions. There's nothing to distinguish between the type of claims in that sense. So there's nothing to say it will be an initial claim from an applicant who has never claimed asylum in the UK before. There's nothing like that stipulated in there. So it does include fresh claims. So in that sense, that is perhaps how we may come across these provisions sooner rather than later, with fresh claims having been lodged from then. Because again, the sort of initial asylum claims from the countries that we're seeing entering the UK tend to be high grant claims, with the exception perhaps of Albania, with all again of that political discourse that surrounds those types of claims. So after the 28th, on or after the 28th of June, and similarly, obviously, it doesn't affect claims that were lodged before the 28th of June that might have been refused either before then and then subject to an appeal that's been pending after the 28th of June, or refused after the 28th of June and then the appeal ensues. So it really is the date of the claim that you need to be worried about. There are transitional arrangements, as I've just set out, but that's also covered in the guidance as well. So that's helpful. There are, or perhaps not helpful with the number of pages that we need to read, but there is a separate set of guidance now from the Home Office that you have there, and then updated guidance dealing with the claims post 28th of June of 2022. So section 31, 30(1) of the Act effectively lists, is quite a useful sort of checklist, a way in, lists the provisions that effectively are going to be sort of mandatory in relation to the determination of a person's claim, the determination of whether they're a refugee within the meaning of the Refugee Convention. And you'll see that's again sort of mirroring the type of language that we had in section 117 of the 2002 Act in terms of Article 8 claims, really imposing that duty on everybody looking at the claim. So not just the initial decision maker, but the courts and the tribunal. And so section 31 deals with persecution, section 32, well-founded fear, section 33, the reasons for the persecution, section 34, the protection from the persecution, and section 35, the internal relocation. So you see there every sort of single step of that determination of a claim is addressed within these five, well, within the 5 sections. With the time that we have, I am going to only concentrate really on section 32 and 33. So just going back to the previous slide, well-founded fear and the reasons for the persecution, and the reason for that will become clear a bit later on. So this is the first part of section 32 that is effectively copied here in the slide for you. And it's effectively setting out the approach to be taken in determining whether a person has a well-founded fear. And the part in red is the most important change in this section. And then it applies to both parts in little a and b that I've underlined. So I'm just going to read that through just to take us through it. The decision maker must first determine on the balance of probabilities, A, whether the asylum seeker has a characteristic which would cause them to fear persecution for reasons of, and that those are the Refugee Convention grounds, and, I should have underlined the and, whether the asylum seeker does in fact fear such persecution in their country of nationality. Okay, so the major change is we've got an increase, arguably, to the standard of proof. So this is to be looked at on the balance of probabilities. And really the practice so far, and we'll look at where that stems from in a moment, the practice so far had been effectively to apply the lower risk sort of standard of proof than balance of probabilities, effectively acknowledging, excuse me, I have to go and mute again. One advantage of remote sessions is that you can fear, you don't need to fear getting my germs. Yeah, so we had been dealing with, I mean, we will still be dealing with the pre-28th of June claims on the basis of there being a real risk and sort of other formulations of that lower standard. And that acknowledges both the difficulties that persons within the asylum sphere would have in proving certain facts that are inherent in terms of their claims, the reasons they fled, the circumstances in which they fled, the inability to produce documentation on certain things, the risks that that might place them at if they were to approach the authorities for documentation, etc. The list can go on. But it also acknowledges really the consequences of getting it wrong. And so if there was a higher standard and sort of a higher effectively sort of threshold to prove certain things, if that is more difficult, the chances of getting that wrong are higher, and obviously the consequences of getting it wrong are incredibly serious in terms of a person's life, a person's treatment, and so forth. But we shift from that now with the Act, and we are stuck with a balance of probabilities. And what's important then in respect of A and B is that it falls to be considered and applied in respect of two things, and that's whether the person has the characteristic and then whether that person has the fear. So it's sort of two exercises of fact-finding that need to be done in respect of a balance of probabilities. It remains to be seen, and there are kind of diverging schools of thought on this at this point, but it does remain to be seen as to how in practice that will be applied. I mean, we can see it how it will be applied by the Home Office. It will probably just fuel the skepticism. It may give comfort to perhaps a propensity, it might not be the right word, but an inclination to effectively be skeptical about these things. It gives them a bit more kind of meat on the bone, so to speak. Whether that translates in sort of appeal decisions, again, remains to be seen. Because effectively it's still a lower standard of proof than we would obviously otherwise have in the criminal jurisdiction, for example. But we can also see it play out perhaps in differently depending on what characteristic we're talking about. I mean, if a person is of a certain race, if a person is of a certain ethnicity, that tends to be more easily proven than if a person is a member of a particular social group, or a person's sexuality, for example, and that those sort of areas always tend to be the sort of the fertile ground, fertile areas of dispute between the two parties on appeal in any event. The same with political opinion, whether a political opinion is actually held, whether political activities are done, whether they are of a high profile nature or low, whether they are genuinely held or not. Those are the sorts of concepts that are now really up for grabs in relation to to the standard of proof following this, because it all falls down to whether that person has a characteristic. And then the second area, whether they in fact have the fear. Again, I think the ground there is likely to be sort of whether it's well-founded or not, whether it's a genuine or not in terms of the fear. That's one of the major changes, and there's a note at the bottom that it's also subject to Section 8 credibility factors, which we've come to know as shorthand for the 2004 Act. And I just signpost at this stage because it's not possible to go into any detail on it, but Section 8 is also due to be amended further, and so there are due to be characteristics and factors to be considered that are going to be added to in Section 8 by the 2022 Act, but from memory that hasn't come in yet. So for that reason we'll limit ourselves to the Refugee Convention changes. Then this is continuing of Section 32. And so again, the remainder of the section, the decision maker must determine whether there is a reasonable likelihood that if the asylum seeker were returned to their country of nationality, they would be persecuted, etc., and they would not be protected. So within the same section, effectively, you've got two sort of iterations of a different, not vastly different, but effectively a different standard of proof, applying to two sets of different components as to what is required to establish refugee status. So balance of probabilities on the characteristic, on the fear, and then reasonable likelihood to effectively what would happen to them because of those characteristics on return. So the mental exercise is really more for the decision maker, but also then a judge on appeal is much more tricky now. Arguably, the risks of getting that wrong, again, from a practitioner's point of view, are higher. So from our point of view, I mean, the risks of decision makers getting it wrong because they're having to apply two standards of proof on quite closely connected issues is quite high in my view, and that's no criticism even of the Home Office decision makers. These concepts are not easy to grapple with, so it just sort of objectively, did we need to go down that route is certainly questionable, but obviously we come from a different point of view than the government. So that's again sort of the major change that we need to be aware of. How, as I said, it pans out in practice is difficult to see, but we then have sort of two further considerations, one of which is at the bottom of the slide, which is that the Act and these provisions in relation to the standard of proof do not apply to Article 3 or HP claims, humanitarian protection claims. So they are, and you've seen it expressly contained in the provisions, they are only covering Refugee Convention claims. So not only are there two standards of proof in relation to that Refugee Convention claim and the different components, if a person is found not to achieve refugee status for whatever reason, it is usual to then go on to whether there's nonetheless an Article 3 breach arising upon a risk of return in the home country. Now, again, in a lot of the claims, as we know, the claims stood or fall really under Article 3 with the Refugee Convention ground. There were only certain types of claim which may have a sort of distinct Article 3/humanitarian protection ground or sort of avenue to pursue. But now, following this, well, it can't stand or fall with the claim because we can revert to the lower standard of proof in relation to Article 3. So if there's a sort of if there's a whisper in relation to an assessment of the evidence that effectively doesn't meet the balance of probabilities test in relation to the Refugee Convention claim, it would fall to be considered if matters are thoroughly looked at, it would fall to be considered on the lower standard in relation to the Article 3 risk. So again, there are this has brought in a level of complexity that perhaps the government had not anticipated, but maybe that is also being naive in relation to what this is designed for. And then the third sort of complexity, which is what flows from what I've set out in terms of the transitional arrangements, is that for some time to come, we are dealing with two systems in terms of assessing refugee convention claims. So all of the pre-28th of June claims are under the previous modes in terms of standards of proof. Post 28th of June, we have the dual standard as far as the Refugee Convention is concerned, but then we have also a dual approach with Article 3 not being affected. So I mean, speaking for myself, that's way too much for my little brain. So really, it'll be interesting to see how this develops. The next slide I'm not going to speak to. Just one sec. Apologies. The next slide I'm not going to speak to very much. It just effectively takes from the new plan for immigration, does set out really what the purpose of all of this is. Clear test against which claims are to be assessed, putting in place a more rigorous standard for testing the well-founded fear of persecution, and explicitly referring to the standard of balance of probabilities, including a credibility assessment, which was always there in any event. And then the second element will consider whether the claimant is likely to face persecution if they return to their country of origin. This will need to be proven to the standard of reasonable likelihood. Okay, so that's where that was foreshadowed. Sorry. And now we turn to section 33. So the reasons for persecution. So there's no shift in terms of the reasons that are listed: race, religion, nationality, political opinion. But there is a significant change in respect of particular social group. So before I say anything else, particular social group, as we saw from the previous section, still remains very much as a ground. So it's not shifted as much as that in terms of omitting that one or departing from that one. But the section 33 little 2 effectively sets out that both conditions need to be met. So the first condition is that members of the group share an innate characteristic, a common background that cannot be changed, or a characteristic or belief that is so fundamental to identity or conscience that a person should not be forced to renounce it. The second condition is that the group has a distinct identity in the relevant country because it is perceived as being different by the surrounding society. So you must show, again, on the balance of the probability. So that comes back to section 32, because it's the characteristic. The characteristic is that you're a member of a PSG. So you've got to show that on the balance of probability. So the shift is there, and highlighting those two conditions having to be met together. So they're not either or. I'm not going to say much more about that, selfishly, because I think I'm not the only one in finding particular social group, and where there's a particular dispute about it, quite tricky to conceptualize and to sort of illustrate in the given case. A lot of the cases that we see, it's either a non-starter or it's accepted that the person is part of a particular social group. So an example of that might be, female heads of household in Sri Lanka, for example, might be lone women, victims of domestic violence, trafficking victims in a particular country, and so forth. But there's been, again, it's an area where there's been a lot of authorities really grappling with these concepts and what might form a PSG and what might not, and whether you are in it and whether you're not. So I'm not sufficiently scholared in refugee law to speak to that with really a great deal of confidence. But that's basically an area to look out for. Again, the school of thought is that this is implementing the qualification directive and a shift towards requiring both of these aspects to be met, and that it's not necessarily anything new, but it's certainly codified in the UK. Certainly it's newly codified as far as the UK is concerned in the UK statute book. The case of DH and EMAP is just set out there. It's a recent case of the upper tribunal, effectively looking at PSG in the context of El Salvador, in the context of those opposing the criminal gangs that heavily operate there. So that's, again, all I'm going to say about that due to lack of time, but it's a useful judgment to really take us through all of those components of a PSG, illustrated in, obviously, the context of El Salvador and the claims from there that tend to be really surrounding the PSG and perhaps whether it comes within the sphere of political opinion. But that is a presidential panel as well, and a very good decision. But as far as I can remember, it's solely dealing with, obviously, the position before the act coming into force, and I can't remember if it specifically sort of foreshadows the changes in the judgment or not, but it's worth going back to in any event with this sphere perhaps needing to be relitigated once these changes bed down. And so we turn to the last section of the talk, which is the mitigating, what I've classed as sort of the mitigating tools. As I said, sort of using the term mitigating with a pinch of salt. I think we've yet to see how these changes are going to pan out, particularly at appeal level. But nonetheless, we can anticipate some shift, some, as I said, some sort of force being, or some comfort being given to those who would be minded to approach things in a bit more of a skeptical manner, in a bit more of a harder edged, with a harder edged approach. So and in the tools, we effectively return to very old case law. But I'm pleased to say that that was endorsed by the UNHCR when responding to the bill. So it gives us, again, force in that respect. We're not just, lefties, just holding on to our own comfort blankets. We do have that sort of validation from the UNHCR. So I think that does give some credence to all of this. And effectively, it's the case of Kaja, Zaire of 1994, and just the quotations there to just extract very briefly, showing really why all of this was important in the first place, that the proof of facts on which an asylum plea is founded is notoriously difficult. There is therefore the probability of a greater than normal uncertainty as to the establishment of historical facts, while the duty of the adjudicator, as they were then, and the Secretary of State is to evaluate the evidence. That evaluation must be undertaken bearing in mind the stress generated by the nature of the claim and possible consequences if refused, including the highly formalistic atmosphere of interview or court. It will be the rare decision taker who, in any case, asylum or not, is never uncertain about some aspects of evidence, particularly where, unlike civil litigation, evaluation is often solely of one version of the facts. So really a powerful reminder there that we've been taken back to thanks to UNHCR. And again, here are some suggestions in terms of the way to try and sort of preserve the ameliorative approach. To have that awareness of the impact of trauma on memory and general variability of memory. This, again, nothing new. It would apply really regardless of what standard of proof you apply. But we already see in this area decision makers ignoring it, not applying enough weight to this, disregarding it for other reasons, and so forth, and including, sadly, on appeal as well. Then an understanding of the reasons why corroboration may not be available. So I touched on that briefly when we were talking about sort of the risks of getting it wrong. But that's another headline, and there could be many reasons for that, and the dangers of imposing one's own views on plausibility on events in a foreign country. So again, plausibility has always been a rife area in terms of responding to refusal letters. We see it day in, day out, the Home Office confusing a person's sort of the credibility of their account with whether an account is plausible or not. And all of that gets merged in their decision making, and all sorts of subjective assessments are made as to whether something is plausible, which can only be formed by that person's own experiences, own knowledge, and so forth. So again, a timely reminder there that is perhaps going to play even more heavily with those standards shifting. I also return to the KS benefit of the doubt. Again, you have the judgments references there. It's all hyperlinked and refers within that judgment to the UNHCR handbook. So again, we sort of may have to resort to those sorts of references again. They'd become quite standard in ASAs. We were told through the sort of COVID directions that we don't need to cite trite law. Well, I think let's keep that under review as well. And so hopefully these references can help you to do that. In terms of the benefit of the doubt, in that case, it was found really not to add much more because of the lower standard. But again, as I said, that may be ground territory to revisit. And I've cited rule 339L, that's within the immigration rules. Again, the hyperlink will take you, reminding that it's the duty of the person to substantiate the protection claim or substantiate their human rights claim as far as the government is concerned, and setting that out in the rules. But also reminding, obviously, that that may not be possible, and what factors are to be considered in sort of gauging whether effectively it's not been possible for the reasons given. And those sorts of factors are that they've made a genuine effort to substantiate their protection claim, all material factors at the person's disposal have been submitted, satisfactory explanation regarding any lack of other relevant material has been given. Person's statements are found to be coherent, plausible, do not counter to available specific and general information. The person has made a protection claim at the earliest possible time. That sort of ties in with the Section 8 credibility stuff, and the general credibility of the person has been established. So just a useful reminder there that really there may be more focus now on whether it's from the initial decision maker or on appeal, once you know what the reasons for refusal are, that you're expected effectively to substantiate, to respond, to corroborate as much as possible, and that will include by way of documentary evidence. And so this does provide a useful checklist to cover the instances where that hasn't been possible, and to really try and spend some time in dealing with that in the statements, in getting other sort of corroborating evidence of attempts to have obtained the documentary evidence and the like. And I've just quoted here in terms of the Home Office policy guidance. I forgot to include a hyperlink to the guidance itself, so apologies. But if you put the title into Google, you will access that straight away. And if I have some time later, I can put it in the chat box as well. And effectively, the guidance itself confirms the principles that we have that have become trite, that have become so well established, that evidence should still be considered in the round. So you've got the sort of Tanvir Ahmed points, the sort of holistic assessments, that you can't just sort of isolate one piece of evidence and then rubbish the rest. The cases of SM Iran 2005 and Karana Karan are also expressly endorsed in that guidance, so it might be useful to go back to that. And then on the benefit of the doubt, the principle of the benefit of the doubt reflects recognition of the difficulties some claimants face gathering evidence to support their claim, and the grave and potentially irreversible consequences if eternal protection is wrongfully refused. So again, sort of nothing, mirroring the sort of the new immigration plan, sort of rigorous tests and that sort of thing in those extracts. And so that again is useful. And then on 339 L, again, you must give the benefit of the doubt, but if all 5 criteria are satisfied, and that there would be no reason effectively not to give the benefit of the doubt. If the claimant only meets 1 or more criteria, you must still consider whether on the facts of this case it is appropriate to give the benefit of the doubt. So useful stuff nonetheless in the guidance that applies, as you can see from the title, to the new claims made on 28th of June 2022. So I hope that you found that was useful. I'm sorry if I had to go through some aspects in swift detail, and I'm just going to stop sharing and see if we have any questions, because I think have we got 1 minute left or 5 minutes left? Sorry, I forget which time. I'm just going to check my program.
Oh, it's 5 minutes. Yeah,
we've got 5 minutes.
Yeah, we've got till 11:20.
Great, thank you, Richard. I do want to celebrate. I think it's the first time I've not gone over ever in the AstenJ conferences. So
well done.
Despite all the snuffling that you heard, the coughing, yeah, I'll take that. Well done, Richard. And let's see if we've got any questions. So we've got Upali's question: where does an overstayer fit in who claims asylum, group 1 or group 2? So I take it that in terms of a person who's perhaps entered the UK lawfully, perhaps in terms of trying to conjure up the scenario that would lead to whether it's group 1 or group 2. So if Upali, correct me if I misunderstand that, but perhaps someone who came here legally, perhaps as a student, overstayed, or came here for work purposes, overstayed, maybe was then subject to enforcement action, or sort of came into contact with the authorities, detained, and then claimed asylum, maybe. That's a good question in terms of thinking about that. I would say they would fall into group 2. From memory, it would be someone who has effectively not claimed asylum as reasonably, when they had the opportunity earlier, when they had the opportunity to do so. So effectively delayed claiming asylum. And so that's one of the provisions. But I'll double check the section 12 to be sure about that. And so on my initial hunch is that it would be group 2, because they could have claimed obviously prior to overstaying, they could have claimed earlier than being coming into contact with the authorities, but that would all be premised on there not being sort of an event that caused the asylum claim. So again, it's all fact dependent. So let's say they overstayed, and everything was fine in relation to the reasons. They didn't have any reason to claim asylum, and then all of a sudden something happened that meant they claimed asylum. If they claimed shortly after that, then arguably then it wouldn't necessarily fall to be considered under group 2. But yeah, the sort of, we could think about what scenarios fit under which group, sort of hypothetically, but what we can find comfort in is that we don't actually really need to do that really now, because it's been paused. So if that remains the case, you can park that really. Another question from Upali: can you share a precedent pre-action protocol letter for JR, at least the headings of mandatory issues that the letter should cover in terms of group 2, group 1 status? I could, but you could also, we could maybe have a discussion about that. If you want to have a more detailed discussion, contact me, Upali, you're welcome to do that. I can give you the heading certainly that I took forward, but as I said, I think you don't really need to, unless you've got a case that does need to be looked at. And if there is one that still needs resolving, you wouldn't really need, I don't think, to go into the pre-action mode. You could just write and basically bring that person to the Home Office's attention, and then it should then flow from there. So if you look at that statement, it does say we will contact, or we will, revisit those group 2 decisions. So really, you shouldn't have to kind of go into the whole detail of formulating that PAP, and a simple sort of FYI letter should be sufficient. Can you introduce discrimination into the JR in group 2? Good question. I didn't in mine, but I did argue that the distinction itself was effectively contrary to the sort of the jurisprudence in terms of recognizing a refugee, and so it was sort of more of an irrationality point that was taken, with again the force of what the UNHCR had said about it. And yeah, Upali, student overstay, so I go back to what I said, but as I said, we can park it because it's not going to happen, hopefully. What grounds did I use in my appeal for group 2 refugees? It was a judicial review. So the one that I pursued was, got 1 minute left, was concerning a minor, which I was surprised about. So he was 14 when he left Eritrea, and then long journey via Libya, detained in Libya in awful conditions for a period of 5 months, reached the UK, claimed asylum in July of 2022, and at that stage was 16. So it was sort of a 2-year journey via Libya and then Italy, quarantined in Italy, then via France, via Belgium for quite a substantial period of time. He had, in his rebuttal sort of representation, had given a detailed statement as to what he had been instructed by his cousin, who was an adult with whom he left Eritrea, again, sort of military service related. So he'd been convinced to leave Eritrea by the cousin, had been under the sort of cousin's, instructions and sort of under his wing for the first part of the journey, but upon leaving Libya, they were separated. So he then found himself without him, and then, in the, as many are, making their own way, and then expressly said, following the instructions of other Eritreans that had decided to help him, and they had instructed him to claim asylum in the UK. So it was quite a detailed statement setting out what he thought needed to be done and his own understanding as a child. And basically the Home Office in their decision had equated the case as not showing that he was under duress, that as he'd been released, that as he'd been under quarantine kind of detention in Italy, he could have approached the authorities then. He wasn't any longer under the duress of others. so could have approached the authorities. Really quite a silly kind of simplistic response in their decision. So in coming back to the grounds, effectively, failure to consider relevant matters, to assess the client's evidence, what the client had said, the client's abilities to sort of understand these things, to understand what he should have done, and failure to look at that in relation to him being a child. So that was sort of the first ground particular to the case. And then, as I mentioned, I tried to sort of take more of the sort of international approach to making these distinctions is unlawful in itself. But yeah, as I said, it caved at the AOS stage. And then the other case that I didn't mention, we did the pre-action and they actually withdrew the decision. And that wasn't the case of a minor, but I forget exactly what we had tried to pursue in the pre-action, but effectively they agreed to reconsider, so it didn't get off the ground. Two more questions. What group for a surplus asylum claim? Well, again, let's park that because we're not dealing with group 2 decisions anymore, but a surplus claim, it doesn't really matter what type of claim it is, because it's all related to the mode of entry, when the person claimed asylum, whether they should have claimed asylum in an earlier country. So whether it's a surplus claim in itself doesn't matter, and it does apply to fresh claims as well, or it did apply to fresh claims. And the last question, once he's granted refugee status, when is he able to, so that everybody can see these. I forgot to click them. So once he's granted refugee status, when she is able to travel back to home country in an emergency situation, for example, need to visit them on black travel documents with permission, is there any policy or law we can stretch it? I'm not sure I understand the question. The black travel document would not permit, so if the question is whether a person can travel to their home country due to an emergency situation, the refugee travel document would not permit you to. It expressly prohibits travel, so it says that on the document from memory, that it's for travel everywhere else that recognizes such documents apart from the country of asylum. So I'm not aware of any change in that respect. It would also be it would be very risky of a person to do that in terms of traveling directly to that country, even for such reasons, because it can provide, I think, the power to the Secretary of State to effectively revoke a refugee status because they have effectively availed themselves from back to that country, which goes contrary to that definition of the refugee status, even in the Refugee Convention that we saw earlier. So yeah, I would say it's a big no until they attain British citizenship usually. But obviously it's a matter for the person themselves. So I hope that's useful, and I'll hand over back to you, Richard.
Well, thank you very much indeed, Sarah. And I'm going to be very strict. I'm going to say 5 minutes for a cup of tea. Just rush to the kitchen, put the kettle on, bring your mug back to your computer. Oh, sorry, I'm not on screen. Oh, here I am back again. Yeah, so I'm going to be very strict, as I say. We'll have 5 minutes to make a cup of tea or coffee, and I'll see you back here at past. Thanks very much again, Sarah. You really covered many topics in that short time and answered those questions that people were eager to hear the answers for. So we'll see you again soon. Maybe you'll be able to take part in the panel discussion.
Yes, I hope so.
Yeah. Oh, that's good. See you later then.
Thank you. Thank you,
Bye-bye.
Richard.
We've had our 5 minutes, I'm afraid. Yes, we've had our 5 minutes, I'm afraid, ladies and gentlemen. So let me now introduce you to Sarah Pinder, sorry, Samina Iqbal, I do beg your pardon. Another very familiar face in these AstenJ webinars. And she's going to be talking about deprivation appeals, deprivation of British citizenship, which is one of my favorite areas, I must say. So I shall be all ears to your talk, Samina. And so without any further ado, I'll let you start. And of course, for members of the audience, if you do have any questions, just type them into the Q&A at the bottom of your screen, and Samina will endeavor to answer those questions towards the end of her talk. So over to you then, Samina.
Thank you, Richard. And yeah, you can all see clearly I'm not Sarah Pinder, but but I thought it was important, just like Richard was saying, you know, an important area. It's important, I think, in this day and age, that we become more conversant with this area of law. Certainly, I found myself faced with, more often than not, deprivation appeals, where the law is changing so fast. And an example of this is that I prepared my slides last week, handed them in only over the weekend, I think. And yesterday morning, we hear that the latest case, which I flagged in my slides, was handed down. What I'm going to try and do is then take you through all the different aspects of deprivation. Let me share my slides now. Oops. See, I think you can see those. Yeah, hopefully that should be clear. Can you all see my slides? I hope. Okay. All right, so that's taking me to look at, first of all then, and I've lost my slides. I don't know what's going on today. I can't seem to get a one with the technology. Okay, have us all there and my screen. Right, there we go. So my first slide is looking at the legal provisions. I think you're all going to be, if you're dealing with deprivation cases, all going to be very familiar with the two legal provisions. It's the British Nationality Act. You have section 42, which deals with mostly cases that involve issues of national security. So looking at whether the Secretary of State may, by order, deprive a person where they're satisfied that deprivation is conducive to the public good. And we look at a few cases that involve this provision a little more in more detail. And then the second provision, which is the more common provision, and more commonly, I say, seen in the kinds of cases that we deal with. 42 is normally dealt with by SIAC, and you would have heard of the more well-publicized cases, but interesting principles of law that have come out through section 42 and the way we approach deprivation appeals. And then looking at section 43, which involves fraud, false representation, or concealment of material fact. And I think what you need to do, and it's important to look at, is the element, look at the refusal letter carefully and check the element under which your client has, if you're dealing with your client is being deprived by virtue of which provision, because it does make a difference, and I'll touch on these issues later. And I say this because they are quite nuanced and it's difficult to cover every single element. But like I say, more generally, I'm going to try and give you the tools to be able to refer back to see what is relevant to what element of the deprivation that someone is facing. And that takes me more generally to the appeal rights. Then I flag the provisions here for the sake of completeness. Sometimes we are faced with appeals and we are unclear as to where the right of appeal arises or whether we have a right of appeal. But here, right of appeal arises by reference to Section 45 of the British Nationality Act. And there is the post-NABA 2022 regime now, which amends these appeal rights by virtue of Section 10(2), and it amends Section 45. And this is new in that there are circumstances in which the respondent can make a deprivation order without giving notice. So it's important to just be aware of that, and then to be aware of where to look for insofar as any provisions are concerned if you're dealing with such a case, because they are retrospective. So it's sections 10.6 to 10.8 which are relevant. And as I say, I'm just flagging those here in this slide for you for the sake of completeness. My next slide covers the new guidance. So everyone's going to be, or anyone who's used to dealing with deprivation cases is going to have recalled Chapter 55, which we all referred to when looking at whether the elements of deprivation. But I think this new guidance here is now reflecting what has developed, what has been developed in terms of principles of law in deprivation cases since 2019, and that's the case of Begum, which I am going to take you through because I think it's just important to, so that we're aware how things have changed. Anyone who is dealing with deprivation cases previously would have been dealing with them in a very different way, on a full merits basis, but we've moved away from there. So why I flagged the new guidance is because the previous guidance has now been withdrawn. You can still look at that link, you can still access that link, but this is the new guidance. This link is live, so it will take you straight to the guidance. And some of the important aspects in this guidance to consider are with reference to statelessness and the effect under Section 42, and I'm going to deal with that in a later slide, but also with reference to other cases and the elements, different elements that ought to be considered when you're looking at cases dealing with fraud, false representation, or concealment of material facts. And then I touched on in the last slide the services of deprivation notice or deprivation notices without notice. This is where you look for guidance about how that operates in law, and whether or not your client, because it may well be that you're faced with a client who's never been served with a notice, but whether your client's circumstances fall within the guidance. If they don't, that's an error in itself insofar as the service is concerned on deprivation in your deprivation case. So important legal issues that could arise and where to look for answers if you need to, and that's in the new guidance. I've flagged out, everyone will recall that there's two elements. One is a deprivation, but also of British citizenship, but also a nullity of British citizenship. So that acts as though British citizenship never existed. It was never granted. So that has its own new guidance as well. I haven't flagged it because I haven't highlighted the link here, but it's easily found, and it follows. It follows the case, the Supreme Court case of Haysaj, which gave us quite extensive guidance on nullity. But for the purposes of today's talk, I'm not covering Haysaj or nullity in any detail. So that takes me to the next slide, where I flagged a number of cases, and I've already hinted towards the scope of the appeal and the change that has been brought about since 2019. And that comes through the law as it's developed in the cases of Begum. I say in the cases because there's been several different cases. I think we've all heard about it in the media or read that there's been another decision in the case of Begum, but it's, for me, certainly it's been unclear what the decisions related to and at what time and the way in which they've been impacted. I know what the principles of law are that emerge from all the various cases. But I think it's important just to have a bit of background to the case of Begum and how it's actually changed the face of the way in which we deal with deprivation cases. So the proceedings started sometimes in 2019, and it led to Supreme Court considering 3 different legal challenges, which were all joined together. Very unusual, but these were unusual. This was an unusual case, unusual in that it was the first of its kind. There've been a few more which have been similar in this sense. But the first decision was the decision of the SIAC tribunal hearing the immigration case, which was hearing the issues of national security, and it was held that held by SIAC that the deprivation decision was not made in breach of the government's human rights policy, and that although Ms. Begum could not have a fair and effective hearing because she wasn't in the country, this did not mean that her appeal should automatically succeed. So that's one of the legal proceedings. They didn't decide the substance of the decision, and that's not considered until February this year. And I'll take you to what was decided in the substance of that decision. And the second and third set of proceedings were about whether Ms. Begum should be granted permission to return to the UK to argue the substance and merits of her citizenship case. And the Court of Appeal, when they heard this, found that she should be allowed to return. But the Supreme Court, on hearing this appeal, held that she could not return to the United Kingdom to argue her main appeal. I won't go into the full legal arguments that were heard there, but what they did do in so far as the merits or consideration of the merits are concerned, and this is where we talk about the scope of the appeal, they said that any such challenge would now only be brought on a narrow public law ground, or can only be brought on narrow public law grounds. Now, of course, keeping in mind that this was a case dealing with national security, so section 42, there was nothing really to highlight the approach in cases which dealt with fraud, misrepresentation, or concealment of material facts under 43. And so we had lots of different litigation. One of the more important cases, which is still good law, I say still good law because there's been a lot of case law that's come through the upper tribunal, and I'll take you to the latest one, about the way in which deprivation cases ought to be dealt with. So it led, looking at Begum, so that I can flag, oops, sorry, that's the wrong slide. Looking at Begum, it wouldn't be a full merits appeal. Now, you're all used to judicial review and the scope of judicial review, so it was going to be looking at that, and I'll go into, in one of the next slides, in some more detail about what actually the courts meant by not a full merits appeal and public law grounds. But coming back to the scopes of the appeal and looking at section 43, Chicheri, I think that's how you pronounce it, is one of the cases which the upper tribunal decided and looked at insofar as a section 43, so it wasn't a national security case, section 43 was concerned, and it adopted the approach as set out in paragraph 71 of the Begum case, and highlighted that the scope is limited. It's no longer just looking at a full merits appeal, not putting all your evidence in and looking at the case afresh by the tribunal. It's very restricted. So that resolved the issue that was raised in several appeals that were refused, or in decisions were made with reference to section 42. I've flagged another 2 cases, both are cases in SIAC. P3 reached the Court of Appeal, and U3 was a decision of SIAC. Both cases considered the impacts of the decision of Begum, and again revisited elements of the Section 42 scope, that is 42 on national security basis. Would it be on public law ground, only on public law grounds? But both agreed essentially with the case of Begum and the way in which the cases involving deprivation have to be considered, or the scope of deprivation cases. I just flagged here the case of P3 first, because it concerned, it's an interesting case insofar as the weight to be given to national security issues, and being completely unclear, if one puts it that way, it was held that it's a weighty factor. National security is a weighty factor, but not too weighty. So it wasn't very clear about where national security lies. And I'm just making that point because it's relevant to one of the later decisions of Begum that that we, on the full substantive merits of the case, that I'm going to talk about in one of the other slides. And then looking at the case of U3 on the factual basis, no matter how compelling the case on the facts of this case, the tribunal again decided, and it was held, that they could only interfere if there was a public law error, even though the factual nexus here was very compelling. It was an entry clearance case. The children of this individual had already been allowed entry back into the UK, but she was being deprived of her nationality. So very drastic consequences, but I just thought I'd flag these because they all endorse the way in which the scope of appeal has developed since Begum. And I've given it away with what the latest approach is by my next slide, which says the pre-Chimmy approach. And I think that's again how you pronounce it. But Chimmy is the latest case of the tribunal, and you'll see that in the next slide. But the pre-Chimmy approach was highlighted by a number of different cases, and I've kind of flagged these three cases, which are still relevant to the Chimmy approach because they're considered within the case of Chimmy. But you have Chicheri here, and it flagged a number of cases, and it and then you've look at the case of Lachi, it's deprivation for fraud. It reviewed some of the principles in KV Sri Lanka, but essentially KV Sri Lanka has now been amended by Chimmy, and you'll see that in the next slide. So keep in mind these cases are still relevant, but subject to more of an analysis in the case of Chimmy, and caveats which have been now highlighted in Chimmy. So looking at Chimmy, now anyone dealing with, as I say, this is now the guidance given by the tribunal about how we, or how the tribunal is to make a decision in a deprivation case. So I think it gives us guidance in turn as to how we want to present our cases to the tribunal. It held that, in this case, it held the guidance set out in Chicheri was consistent with the Supreme Court decision. So it requires, again, the first stage to be consideration of the condition precedent if it's satisfied. And you're looking at that, that's looking at, and I'm going to come to that in more detail in one of the next slides, looking at that with reference to judicial review principles, but I won't say more about that. So it's whether there was fraud in the first place, and looking at whether the Secretary of State's decision was wrong in law, because that was not the case. The second stage that the tribunal said that must be considered by the first tier tribunal deciding these cases is whether there's been the Secretary of State have erred in their decision, because keeping in mind it's the discretion of the Secretary of State. If you look at the provisions of 42 and 43, discretion of the Secretary of State to deprive. So whether they've exercised their discretion to deprive or whether they've materially erred insofar as that discretion. And then if so, the appeal falls to be allowed. So that's the second stage under the circumstances in which an appeal can be allowed. And then you're coming to the third stage, which is looking at if your client doesn't succeed with reference to either of those two elements, then the third stage is to look at what are the immediately reasonably foreseeable consequences. Now, before I go on to talk about any of those three elements in more detail, what I want to do is just flag up or look at the factual nexus of the case of Chimmy. This was an appellant who was born in 1977. She was born in Cameroon. In 2000, she moved to France, formed a relationship, and with the help of her partner, she applied for French nationality. And what she did was submitted her Cameroonian birth certificate and was issued with a French birth certificate, which then allowed her to receive a French or apply for a French passport. But her relationship with her partner then ended. And what she did was decided to move to the UK, which she could do quite freely under free movement rights. And had actually met her husband here, had a child with him, and then applied, having lived here for a number of years, applied to naturalize as a citizen in September 16, which she duly did. But as a dual national, she sought to then apply to renew her French passport, and she had a number of difficulties with that. And what happened was that the Secretary of State then was passed information from the French authorities revealing that the French passport had been obtained on the basis of a false birth certificate. So the birth certificate that she'd been issued, the French one, was false, the one that she'd swapped from her Cameroonian birth certificate. So she wrote to the Secretary of State because action was taken against her to deprive her of nationality, and she wrote to them to say that she'd been advised and she'd acted under the guidance of her then partner throughout the process, and she had no reason to suppose that the passport wasn't valid or that the birth certificate wasn't valid. But she was issued with a notice of a decision to deprive, and on the basis that the birth certificate, the French birth certificate, which allowed her to obtain a French passport, which then allowed her to exercise treaty rights in the UK, which then allowed her to naturalize, were all on the basis or the consequences of fraud, albeit not her own, on the evidence that she was presenting. And so, as I've highlighted, what the tribunal decided was that first they would have to consider the discretionary decision of the Secretary of State to make that deprivation notice only on the basis only by consideration of public law grounds. So that's looking at this first stage here. So if you have a case which you're addressing, or you're making representations on, or preparing an appeal skeleton argument, you want your skeleton argument or your representations to address it in the following three stages. So have subheadings about the condition precedent, discretion, reasonably foreseeable consequences. So starting with the condition precedent, as I say, on the facts of Miss Chimmy's case, they then went on to consider the issue of discretion, and whether on the merits of the case, deprivation was the correct, not on the merits of the case, but they were only deciding whether there'd been a material error of law on the Secretary of State's approach in exercise of the discretion. And we're going to see that with reference to both elements, it's very difficult to demonstrate both elements. You've got to essentially, I mean, it will be very difficult, but I'll look back, I'll look forward in one of the slides as what might amount to an error of law, but it's very difficult. I think most of us will have found for us to overcome either of these two stages. If you haven't overcome these two stages, then look at the reasonably foreseeable circumstances. And as I've set out, that's the clear structure. Part 2 to Chimmy, or the other parts of the head note, are quite clear about the evidence that has to be considered. So when you're looking at public law grounds, as we do in judicial review cases, we look at the decision that was made, and we don't add further evidence because we can't. The decision was made on the basis of certain evidence, and the challenge has to be made with reference to that evidence, and that evidence not being not being properly considered, and so far so on. So you can't add further evidence. And this case of Boudica, this is a case where which I was quite pleased at the time, which found that you could perhaps put in further evidence in relation to this element of the test. But it's held here in Chimmy that Boudica should not be followed in that respect. So that's unfortunate. But that isn't all. So as I've already highlighted, we're looking back at the last element, which is reasonably foreseeable circumstances. If you haven't succeeded with reference to the first two stages, it's then okay to add in evidence which was not before the Secretary of State, and you can so that they can revisit their conclusions. And this is consistent with the Administrative Court Guide Judicial Review, which provides guidance on the judicial review principles. So that at that stage, you can put in further evidence. But I'm going to, as I say, talk a little bit more about reasonably foreseeable consequences and the difficulties you might have with demonstrating that. So this sets out our structure in the first instance. And taking you then, as I promised, to condition precedent. Here I've set out standard of proof is a civil standard. So this has been set out some time ago. And as I've already highlighted, you're looking at this as a public law challenge. We do that, as I've said already, as in judicial review cases. So it's not going to be difficult for us to look at the decision and to try and identify what the difficulties are with that decision, where the law, where the Secretary of State may have got the factual nexus of the case wrong, such that they've reached the decision that they have. And I flagged up here the case of Chimmy again, because it refers back to this very important paragraph in the judgment of Begum. And it highlights that the task of the tribunal is to scrutinize established public law criteria, whether or not the conclusion that the condition precedent, that is whether the fraud, the concealment of material fact, or the misrepresentation to deprive, that's relied on to deprive the appellant of citizenship, is infected by an error of law. Okay, it's not the task of the tribunal to undertake a merits-based review and a redetermination of the decision on the exercise of the condition precedent. It's just changing our mindset, I think, and I say this because it's important to change our mindset to be able to prepare. This is not to say that this is going to be perhaps the last word on the way in which cases are dealt with, and I say that because there has been some development and challenges throughout since the Supreme Court decision in Begum in the approach to the public law challenge. So But for now, when we are preparing cases, the best way is to ensure that you prepare it as if it were a judicial review, and the challenge front load your challenge by putting in as much evidence in the first instance before a decision is made, so that that can be considered with reference to your case. And I'll give you an example. When I talk about front loading your application or providing information to the Secretary of State before they make a decision to deprive, perhaps if you've been a victim of trafficking, or there has been some form of domestic violence, or you've not known about the fraud, or there's some elements, those elements that led to this issue arising, or the fraud arising, or the material, the misrepresentation arising, what led to those circumstances, and backing it up with evidence before they make their decision. Because if they fail then to take into account that factual nexus, then you have a prime challenge there by reference to a public error of law. So that's why I say it's changing our mindset to how we approach deprivation appeals. Let's not wait to receive the decision. Let's be proactive and put in the information as much as possible if we have notice of the deprivation taking place. And that takes me to the next slide. Now, I called this discretion. You'll see these are my amended slides. I've slightly amended it because I've talked to you about Begum and paragraph 71. And actually, this is the list that Lord Reed highlighted in the case in the Supreme Court in Begum as to what amounts, or what could amount to public law error. And it's not an exhaustive list, so there could be other elements that you consider or that may become evident in the decision that you're dealing with. But what you're looking at is whether the Secretary of State, so reasonableness, whether they've acted in a way that no other reasonable Secretary of State could have acted. Oops, and my slide has skipped again. I don't know why it keeps doing that, but we'll get to the bottom of it. There may be a policy that they've not considered. So I mentioned the issues of trafficking. Perhaps there is an element that they fail to consider with reference to someone who's been trafficked under a certain policy that would be relevant. I'm just trying to give a wide example, trying to ensure that we think about everything. Maybe they've considered irrelevant matters which don't go to the particular element. And that's where I said about looking at the element under which your client is going to be deprived or has been deprived of their nationality. Is it with reference to fraud, misrepresentation, or concealment of material facts? So whatever the factual nexus is may not match up to the element that they're looking at. And then they may have failed to consider weighting matters, procedural impropriety, or section 44 may not have been applied properly in that case. And 44, if I can just highlight, is with reference to statelessness, and I am going to address that in one of the next slides. You may have seen from the notes already. Okay, so that's discretion, and Begum, paragraph 71, which is important for us to look at. And that takes me to statelessness, and the guidance is very helpful in relation to this, because section 44 is quite clear, or was quite clear, that where a decision to deprive a British citizen on the basis of it being conducive to the public good is being made, it cannot be made if the Secretary of State is satisfied that it would make a person stateless. Now, that was one of the grounds that was run in the Begum case, But in the Begum case, it was found that she would be entitled, she was under the age of 21 at the time, and she was entitled to nationality of Bangladesh by virtue of ancestry through her parents. She was born in the United Kingdom, but it was by virtue of that that she was entitled to another nationality. So we're looking at statelessness. It's an important issue to consider on the facts of your case. However, what we've seen now, and this I think is with reference to all the litigation over the years since at least 2019, is the introduction through section 44A that even if on grounds of conducive grounds, so national security elements, even if someone is rendered stateless, if they have conducted themselves in a manner seriously prejudicial to the vital interests of the UK, and if there are reasonable grounds for believing that the person is able to become a national of another country, then they can still be rendered stateless. The action can still be taken out against them. So that's always been the case. But the second element, so I think I've confused myself there, and might be confusing all of you. So so 44 was the rule, then they had 44A, which was almost an exception, that they had to show a second element, which was the manner prejudicial to the vital interests of the UK. So it gave a slight context to being stateless where there are conducive grounds to deprive. And then came the other element here, which was a decision to deprive with reference to grounds of fraud. And the deprivation can be allowed on such grounds. I don't think there's anything with reference to the I've seen misrepresentation or concealment, but with reference only to the fact sorry, just so that I get it clear in my head so I can explain it well. So they can allow deprivation if the person is made stateless, then you consider the impact of Article 8 or other factors which essentially I would think are Article 8 factors, right to family life and so on, and the impact on the person and the family and their life here. So if it's on grounds of fraud, then you're looking at the impact on a person and their family, not on grounds of conducive to public good. So I hope I've made that a little bit clearer there. And looking at that, it brings me to the last stage. Then I popped this slide in between the structure that we're looking at for the tribunal in any case that we take. And the third stage is reasonably foreseeable consequences. So if you've got through the first stages, you get to this last stage, you can't succeed on those, or you're just addressing this in your representations, then look to the impact on an individual of deprivation and what is the reasonably foreseeable consequences. And we've got to make an effort not to confuse this, a concerted effort not to confuse this with looking at what would happen if they're deprived on their family life and so on. And I say this because this case of Muslija, I think it is, was quite clear that there's a boundary between reasonably foreseeable consequences and a proleptic analysis of an individual's removal. So what would happen if they're removed? Proleptic here in this context means an anticipatory analysis of an individual's prospective removal or deportation. And that's because you all know that once they are deprived of citizenship, there is a limbo period in which they get to make representations to the Secretary of State about removal, deportation, and anything else that will impact them if they leave, which would then entitle them to leave to remain. So we can't confuse that aspect of the claim together with the reasonably foreseeable consequences. And I think there's going to be a very small window of consideration of factual nexus of what can be reasonably foreseeable, or what might succeed insofar as what is reasonably foreseeable, so that deprivation ought not to take place. But you really have to address it by way of full circumstances. And I think one of the cases in which we've put, or the way in which I've generally argued it, is that if there is something within the family circumstances which prevents anyone else, perhaps, let's say, the breadwinner is the person being deprived of citizenship, and the rest of his family have no other financial means, but it's due to the factual nexus. It's not just because let's say the wife or partner just can't go and work. It's because of certain relevant factors specific to their case, why depriving him would have an impact on their family and private life immediately. Because let's not forget, during the limbo period, which the Secretary of State says between 8 and 16 weeks, I can't remember, maybe it's longer, 24, it's usually in the refusal letter, they say that limbo period is not, there's nothing foreseeable within that period which would impact on an individual's Article 8 rights. So it's worth us considering what those circumstances are and being very fact specific. And if you see here, the head note of Miscellany is very clear that exposure to the limbo period without more cannot possibly tip proportionality balance in favor of an individual retaining fraudulently obtained citizenship. So they're very clear that just because you're in a limbo period for whatever time, it's not enough. What are the circumstances of this family during that limbo period? And it's up to us to put those forward. I'm flagging this this issue of delay in this slide. It's important because it may be a relevant factor in your case. I'm not going to go over in much detail, but this case of Lachi was successful insofar as there being a delay. There was inaction for 10 years after he'd been told that he was liable for deprivation, and the Secretary of State didn't dispute the delay. And without more, on the facts of this case, inaction wholly unexplained, and at the time, and for so extraordinarily long a period, it was sufficiently compelling when taken with all the other circumstances, such that deprivation was not effective in his case, and that was, or not lawful in his case. So that's one of the few cases in which delay is relevant, and I think it's worth everyone having a look at that if you do have a case of delay. But these are the legal principles that can be relied on, and for you to go back as a point of reference. Materiality. So the issue of materiality, and I thought this would be interesting to look at because many of us will have faced such cases. Certainly I have recently been dealing with such a case. It was, and I flagged Slayman. I don't know if anyone, gone back again. I flagged Slayman because it was so close to the facts of my case. It was a young man who had arrived in the United Kingdom. He lied about his age and nationality. Here he only lied about his age. And then he was granted leave with reference to the legacy case, and granted ILR, applied for British citizenship, received British citizenship. And the test used was, but for his initial deception about his age, he would not have had lawful stay, and therefore would not have eventually qualified for citizenship. However, on the facts of this case, it was found that age and the Home Office file showed that age was not relevant to his grant of ILR. So the question was the deception on the date of birth directly material to the decision to grant citizenship, and the answer was no. On the facts of my case, we have nationality. It's slightly different. It's the issue of nationality that was considered, and that he'd lied about, but we say it wasn't relevant to the issue of his grant of nationality. Now, I flagged this case of Matusha simply because it was used in argument, and it doesn't deal with deprivation, it deals with revocation of ILR. And the reason it's relevant is because it was used in this case of Shaiti. And Shaiti was the case that I said was handed down yesterday. It was a case heard 2 weeks ago insofar as the issues of deprivation were concerned. And I'm jumping from my case, from Slayman to my case to Shaiti, because they all tie together and bring us to what the approach of is in relation to these cases. So keeping in mind that Slayman was only a lie about his age, which on the Home Office file was not relevant. In my case, it's nationality, and in the and that was the same in the case of Shaiti that was heard. This link is live, so it takes you straight to, it was heard on the 20th, 21st, and it takes you straight to the decision of the Court of Appeal now, so you can refer back to that. But in my case and in Shaiti, the case of Shaiti, it was argued and it was held in Shaiti that there was a difference in lying about your age and lying about your nationality. And with reference to lying about your nationality, if the Secretary of State had made reference to the deception or the concealment of this fact in the course of their, or they'd asked the question about good character requirements, and which requires you to make a declaration if there's ever been, if there's anything that is which would not stand up to the good character requirements, and if you've ticked no, and then it's found that your nationality was an issue that they might have considered which was relevant to your character such that they wouldn't have granted you nationality, then that becomes relevant. It's not simply the Home Office have said age is not relevant. It may have become relevant, but they just simply, it was argued in Shaiti, they didn't know about his nationality. It was only later when they came to deprive that they found out that he was not the nationality that he declared himself to be. So in Shaiti, it was decided that and just going into a little bit more detail about that case, in the first tier tribunal, the Home Office had not really relied on that issue, so the judge had allowed that case with reference to this case of Slayman and the principles there. What was decided, but in the reasons for refusal letter, they'd clearly set out that had they known about his nationality, that would have been very relevant to the materiality of the grant of leave. They may have decided to take it into account, or they may well not have decided to take it into account. And it was argued that, well, the fact that it was not argued in court, but was in the refusal letter, meant that they couldn't later rely on it as a grounds of appeal to the upper tribunal to say that that's the position of the Secretary of State. However, the Court of Appeal said it was relevant. We have to look at all the elements of the refusal letter. And so that's incumbent on us when we're looking at a decision letter to address every single element insofar as the allegations are concerned of fraud and so on. It may well be that he did make them aware, or it may well be that they were aware of his nationality when, let's say, he applied for his parents to visit from, in my case, Albania, which was actually the factual nexus for my case. They knew about his parents and the visit from Albania, and we said that they knew, therefore, of his nationality at quite an early stage. So this, in our case, was a relevant factor known to them, and therefore they couldn't say that they hadn't really taken it into account when making the decision and looking at good character and the decision to grant a nationality. It didn't work. Sorry, it did work. Our appeal was allowed, but we just had permission granted against us, and we're going to we're drafting I'm in the midst of drafting a Rule 24, but quite similar to this case is it's quite similar to the case of Shaiti, where all these factors may or have to be looked at a little bit more carefully and may or may not be relevant. Sorry, I've taken time to go through that and explain that because it's a relevant issue insofar as deprivation is concerned. I flagged this case of Matusha because on the facts of this case, his ILR was revoked because he had not declared his nationality. So the Secretary of State was relying on this case in Shaiti to say that it is a relevant factor, and had they known about it, it would have factored into their weighing or their discretionary decision. So that brings me to the end of my slide, this particular slide. And I know I'm coming close to time and I don't want to run over, but I just want to take the time to flag one last thing. In the case of Shaiti, there was they did reconsider the scope of Begum and whether or not it would be restricted simply to a public law grounds. So as I said right at the start, when we're looking at this issue of public law grounds, it's not Begum's not the last word. All these cases are not the last word. There appears to be a continuous challenge to the scope in which deprivation appeals are being considered. But the Court of Appeal said as much sympathy as they had, they refused to consider this particular issue as much sympathy on the facts of this particular case, and for the first tier tribunal, they weren't going to consider this particular issue with reference to the scope. And I'm sorry, I've come to the last slide and I'm not going to talk to this slide, but it's self-explanatory. Other matters that you want to look out for are if disclosure of material facts. In this case, he had criminal convictions after he put in his application for deprivation, but before a decision was made, and it was held that there was an obligation to disclose that. And then I highlighted very early on that in February 2023, a decision was made in the Shamima Begum case on the factual merits. And I've set out some elements there insofar as the decision. I know it's being appealed further, but it was, they rejected the argument that just because the Secretary of State had not considered, because this was the very first time it was considered she was a victim of trafficking, but just because the Secretary of State had had not looked at the fact that she'd been trafficked before, taken it into account when they made their decision, it didn't render the whole decision unlawful, because national security, whilst not an absolute imperative and doesn't trump everything, it certainly had a wide reaching range such that it outweighed the fact that that issue hadn't been considered. And so I'm sorry I have overrun, and I'm not sure whether there are any questions for me. I'm going to stop sharing my slide. And I'm just looking at the question box.
I think there is just one question at the bottom from Adeniyi Adewoye about Chimi.
About Chimi, let's have a look. Does the Chimi approach cover deprivation for serious crime as opposed to fraud? I need to check because I was reading around it, and I think that Chimi will also, the approach for Chimi will also be used for serious crime as well. But I can check that and come back to you on that. I can pop it in the chat box perhaps.
Well, I guess that's about it, Samina. Thank you very much indeed. And at least I got your name right this time. Anyway, talking about names, I was reading about Shaiti in the Free Movement blog yesterday, and I thought, now there's a memorable name. Sometimes, you know, some names of these cases are not very memorable, but I think that one is. Anyway, thank you so much for telling us about that and about many other cases in the deprivation field, which is interesting and complex. So thanks again.
I'll see everyone back in the panel discussions.
Oh yes, you'll be back in the panel discussion this afternoon. That's great. So I've got the pre-lunch slot. So I'll try and romp through that in good time for lunch. And I like alliteration. So I've called this talk Migration Miscellany, and I'm kicking off with a further alliteration, Brexit bemusement. Now, what is this aspect of Brexit? Well, I'm trespassing somewhat on Lawrence Youssefian's talk this afternoon about criminal deportation appeals, because it involves an appeal against deportation. Now, this particular case starred an Albanian who'd been working, taking a leading role in running a cannabis farm in Cornwall, quite a way off the beaten track. So he was at it from early in the year 2020 to late in the year 2021. Eventually, the law caught up with him and he was charged with the offense of cultivating a Class B drug. And he was sentenced to over a year in prison. So what would the result of that be? According to the UK Borders Act 2007, yes, automatic deportation. But hold on, something else intervened. This chap, although of Albanian extraction, was married to a Spanish lady. So he was the family member of a person who had actually acquired pre-settled status, and he had got it as well. So would that make a difference? The fact that he had a right to reside under European law? Well, he would have had a right to reside anyway until the end of the year 2020, because that was really when European law ceased to have effect altogether in the UK. So was he liable to deportation under the UK Borders Act? Well, the Home Office thought he was, because even though it's kind of well known that if you commit an offence before the end of 2020 and you're a European citizen or the family member of a European citizen, you're not subject to deportation under the 2007 Act. It's not automatic deportation because that's conducive to the public good. No, it has to be under European law on the grounds of public policy, public security, or public health. So it's more difficult to deport you if those are the grounds that have to be relied on. Anyway, the Home Office thought they were in the clear because he had committed a continuing offence. He'd started before the end of 2020, long before the end, but he carried on well after the end of 2020. And that meant that he was committing the offence when he no longer had the protection of European law. So if you take a look at the second paragraph of the course notes, this refers to a new regulation 27A, which was inserted into the EEA regulations 2016. And as a result of, well, this is not a memorable name, the Citizens' Rights Application Deadline and Temporary Protection EU Exit Regulations 220, which preserved parts of the EEA regulations beyond the end of 2020. So this new regulation says an EEA decision may be taken on the ground that the decision is conducive to the public good, but a decision may only be taken under this regulation in relation to a person as a result of conduct of that person that took place after IP, that's implementation period, completion day. Well, looking at that turgid language, it must mean that any conduct that took place after the end of 2020, the end of the implementation period, may be used to deport a person on conducive grounds, even if he's European or the family member of a European. So anyway, the case proceeded to an appeal, and eventually it came before a judge of the first tier tribunal, and he kind of teased, played with the representative, well, both representatives, both counsel for the appellant and the Home Office rep, because they were both going on the assumption that it was correct for deportation to be decided under the UK Borders Act. And he invited further submissions from both representatives and adjourned the case. Neither representative was sure what he meant, why he wanted the further representations or submissions. But anyway, the case reconvened, and much to everybody's surprise, the judge announced that what was relevant was sections 6B to 6D of the 2007 Act. Now, nobody had heard of this. It's exception number 7 to deportation on automatic conducive grounds. There had been 6 exceptions, but the 7th was added on the 31st of January 2020, which is actual Brexit day when we officially left the EU, although there was a further implementation period that continued until the end of the year 2020. So exception 7 is where the offence consisted of or included conduct that took place before IP completion day. So here was the answer. This chap had been growing cannabis before the end of the implementation period. So never mind that he carried on doing it afterwards, he was in the clear. He was covered by exception 7 and could not be deported on conducive grounds under the 2007 Act. No, I'll just divert a bit to another aspect of this case. The chap had been in detention for 5 months following the custodial part of his sentence for growing cannabis. He'd been in, I think, Coldbrook Immigration Removal Centre. So what do you do when you've been in detention at a Home Office facility and your detention turns out to have been unlawful? Well, his lawyers are onto it. A pre-action protocol letter, or I should say a letter before action, has been sent to the Home Office, the litigation team in Feltham, and a claim is threatened, a claim for damages for false imprisonment, and this would be a claim to the county court. So it's not a judicial review claim, it's a money claim to the county court. And of course, the litigation people in Feltham will hand the matter over to the government legal department. And one may expect that the Home Office will have to concede that detention was unlawful and will probably be suggesting a figure to settle the claim out of court. Okay, well, moving on then from this little byway of a survival of European law into the post-Brexit era, now we go to a very familiar kind of immigration matter. There has been provision for donkey's years for elderly dependent parents or grandparents to come to the UK. And since Appendix FM was drafted in 2012, they have come within that appendix. However, recently, the adult dependent relative section of Appendix FM was deleted and a new appendix was set up, one of the many new ones that there have been in recent years, called Appendix Adult Dependent Relative. In terms of substance, there's not that much difference, but there's actually more in this new appendix because it brings in stuff that was in Appendix FM-SE, namely the evidence required for proof of maintenance and accommodation. And also there's been brought in the requirement, which used to be at paragraph 35 of the immigration rules, that the sponsor should give an undertaking that for the first 5 years after the dependent relative comes to the UK, there will be no recourse to public funds. However, the really serious bit of the adult dependent relatives rule is the requirement that the dependent must, as a result of age, illness, or disability, require long-term personal care to perform everyday tasks. So that's quite a high hurdle to jump. And then also, if it is an entry clearance application, which it usually is, the applicant must be unable to obtain the required level of care in the country where they are living, even with the financial help of the sponsor. Because either the care is not available and there is no person in that country who can reasonably provide it, or the care is not affordable. So those have survived completely intact from Appendix FM. There is one good thing also which has survived the transition from Appendix FM, and that is the equivalent of Gen.3.2. This is the fallback provision where if you don't satisfy the rules on family life under the appendix, you can nevertheless rely on Article 8, as it were, outside the rules, or used to be outside the rules, if, because of exceptional circumstances, there would be unjustifiably harsh consequences for you or members of your family if you were not allowed to stay in the UK. So it's the old Article 8 fallback position. Now, this has been transferred into Appendix Adult Dependent Relative but without the requirement of showing exceptional circumstances. It just goes straight into unjustifiably harsh consequences for the applicant or their family. So that's an easing, as it were, and it may actually be relied on quite often because it's difficult to actually jump the hurdles that I've just recited about requiring long-term personal care and nobody being able to perform that in your country of residence. However, I got involved in a case of an elderly lady who had come here as a visitor, and she'd made an application for leave to remain as an adult dependent relative. Now, how come she was able to do that? Because we were looking earlier on this morning at the situation of people who come here on a visit visa, and they're not allowed to apply for any other category or route. They can't switch to anything else while they're here as a visitor. So how come this old lady was able to apply for leave to remain on a route which you would have to apply for entry clearance for? Well, the answer to that is that at the time when she applied, there was in force what was called the coronavirus concession. Now, it varied from time to time. It was being updated, in fact, frequently, sometimes 2 or 3 times a month. Little changes would be made. But for quite a long time, there were 2 main elements of this concession. One was for people who were stuck in the UK. Their leave was going to run out, but they couldn't travel because of the travel restrictions imposed during lockdown, although they wanted to get home, and they were concerned that if they had to stay in the UK and become overstayers, that would affect future applications to come here. So the Home Office offered them a thing called exceptional assurance. It wasn't leave to remain, but it would protect them from any adverse consequences of overstaying. Now, the other cohort which benefited from the concession was people who were here in the UK with limited leave, but who didn't want to get home. In fact, they would much rather stay. So they were given the opportunity to apply for leave to remain, even if normally in the category in which they were here, they would not be allowed to switch to anything else. They would have to go home and apply for entry clearance. So it was that cohort that this old lady came within. She was here as a visitor. She would normally have had to apply from abroad for entry clearance as an adult dependent relative, but lo and behold, she was able to do it because of the coronavirus concession. Now, I've heard of other people who've been able to take advantage of the concession in similar circumstances. But I was recently involved in a case where the application had been made under the coronavirus concession for leave to remain, and it had passed muster when it was refused by the Home Office. It was refused on the basis that the applicant was not, as claimed, in a genuine relationship with a British citizen. It was said that she was not a partner at all. So that was the basis of refusal. When the matter came before an immigration judge, he did allude to the fact that the application had been made under this coronavirus concession, but he simply accepted that the applicant, the appellant, was able to do that. And when it came to closing submissions, the HOPO didn't say anything about it not being possible to use the concession. Rather, he said that the strict requirements of Appendix FMSE had not been carried out because the sponsor, who had in fact, a great deal of money, hundreds of thousands of pounds, or the equivalent in Hong Kong dollars, in a branch of the Bank of China in Hong Kong. So although he was relying simply on savings, you have to have £62,500 in savings. If that's all you're relying on to meet the financial requirement, well, he had hundreds of thousands of pounds in savings, no problem. But he had not got his bank statements translated from the Chinese script into English. And although it was as plain as a pikestaff that the figures were Hong Kong dollars, and we'd submitted an Oanda currency converter, it's roughly 10 Hong Kong dollars to the pound, we hadn't submitted translations of the bank statements, which is a requirement of Appendix FMSE, one of the specified requirements. So anyway, the judge allowed the appeal, saying that, oh, he had more or less fulfilled all the requirements of the immigration rules, and therefore, according to, you remember the case TZ Pakistan and PG India, Sir Ernest Ryder, Senior President of Tribunals, if you fulfill all the requirements of the immigration rules, then you must automatically succeed under Article 8. It's determinative of an Article 8 claim. Not so, said the Home Office when they sought permission to the upper tribunal. The author of the permission application said that this was not what the coronavirus concession said at all. What's this nonsense about visitors being able to switch categories? And this was followed up in the respondents' review by, this had been preceded in the respondents' review to the first tier appeal that said that looking at the coronavirus concession, the woman should have applied for exceptional assurance and not leave to remain. Anyway, to cut a long story short, the appeal came before the upper tribunal, and we still had to argue that on its correct meaning, the coronavirus concession did allow visitors to switch to something else in country. And then the upper tribunal judge threw a spanner in the works by saying, well, there's going to be a rehearing of this appeal. It was decided there had been an error of law. Can you rely upon the coronavirus concession at the present time, or for that matter, at the date of the original Home Office decision to refuse? So that's what we have to cope with now. Oh, sorry for that little diversion. But let me get back to this lady who'd been refused on the basis that she could be sent back to Pakistan and she could be looked after there. She didn't have to stay in the UK and be looked after by her daughter and son-in-law. So anyway, by the time the case came on before the first tier tribunal, her condition had deteriorated catastrophically. When she first came, she was very distraught by the recent death of her husband, so she was depressed, but she wasn't doolally. But by the time the appeal came on, a couple of years had gone by, and both physically and mentally, she had deteriorated rapidly. She was now wholly bedbound and incontinent, and her Alzheimer's disease had progressed to the stage where she didn't know where she was or who she was. However, that didn't stop the Home Office from continuing to argue that she could very easily be found a care home or something like that in Pakistan, and she could go back. Yes, actually, it would have been quite a job to get her back. In her condition, the airline would have required a large sum of insurance. She would have been required to be accompanied by a medically qualified person and so forth, just to get back to Pakistan. Anyway, the argument which I'd been using that this was something which engaged Article 8 under Gen. 3.2, which was still there in Appendix FM. These were exceptional circumstances, and it would be a breach of Article 8 for her to go back to Pakistan. And what the judge said, much to my surprise, was that, well, actually, according to the adult dependent relative rule, she could go back to Pakistan. She could be looked after there. Her sponsor can afford it. And so he wouldn't allow the appeal under that rule, but lo and behold, he allowed it under paragraph 276 ADE, which is now, of course, Appendix Private Life, because he said that according to the old Little Roman 6, 276 ADE 6, there would be significant obstacles to her integration in Pakistan. So he allowed it on that basis, private life, with the same net result, except that it would be a 10-year route to settlement rather than indefinite leave to remain under that rule. But at least she's got to stay in the UK now. So there it is, the new appendix. Now, my final heading is double whammy. And this is to do with people who are liable to be refused entry clearance or indeed leave to remain on the basis of previous behavior in the UK. And let's look, first of all, at how this situation was dealt with by the former general grounds for refusal. So you'll remember the old paragraph 320 of the immigration rules, which would prevent people from getting entry clearance or leave to enter because of bad things that they've done. Now, most of the sub-paragraphs of paragraph 320 didn't apply to Appendix FM, so it wouldn't stop you coming as a spouse or partner or child. But one of the sub-paragraphs that did affect Appendix FM was sub-paragraph 11. And this could be applied by an entry clearance officer if you had previously contrived in a significant way to frustrate the intentions of the rules by, and then there's a list of 4 things: overstaying, 1, breaching a condition, 2, being an illegal entrant, 3, or using deception in an application, 4. And now that was significant because not just did you have to have previously committed an immigration breach, such as overstaying, but also there had to be aggravating circumstances. And a list of these was given, including things like failing to report to the Home Office, or as they like to say, absconding. Now, sub-paragraph 320 in general has been deleted, and it's been replaced by Part 9 of the immigration rules, which in parts is quite difficult to understand. I think I've found one bit which certainly is. So this replaces the general grounds for refusal with what it simply calls grounds for refusal. And the equivalent of the old paragraph 320.11 is 9.8.2. So this does affect Appendix FM. Now, the things that have to be shown for this new rule to be engaged are rather different from the previous 320.11. There are three ways which have to coincide in order to engage 9.8.2. So the applicant must have previously breached immigration laws by doing things like overstaying, and the application must have been made outside the relevant time period in paragraph 9.8.7. Now that's a bit opaque. The relevant time period refers to re-entry bans. So, for example, if you've overstayed in the UK and you delay your departure, it used to be you could stay on for 90 days and that wouldn't be held against you. Now it's 30 days. But if you stay on for longer than that, and then you leave at your own expense, voluntarily, then you have to wait for a year before you reapply to come back. So effectively, it's a re-entry ban for 1 year. And various other time periods are in place depending on what you've done. And the maximum re-entry ban is for 10 years because you've used deception in a previous application. So deception causes you to have a 10-year re-entry ban, but other things not so long. So anyway, that's B under 9.8.2, and then there's C as well. So this says the applicant has previously contrived in a significant way to frustrate the intention of the rules, or there are other aggravating circumstances in addition to the immigration breach, such as, and then a few non-exhaustive examples are given. Well, the structure of this rule is very different from the structure of the previous rule. Now, the previous one started, the applicant has previously contrived in a significant way to frustrate the intentions of the rules by, and then it listed overstaying, etc., and aggravating circumstances. So the whole caboodle was previously contriving to frustrate the intentions of the rules. So everything came under that heading. But now we've got three different headings: previous breach of the rules, trying to come in before the re-entry ban has expired, and contriving to frustrate the intentions of the rules. So in other words, a breach of the immigration laws, like overstaying, is no longer contriving to frustrate the intentions of the rules. So what actually are, or what is it to frustrate the intentions of the rules? Well, in fact, it's completely opaque what that is, although they would seem to be other aggravating circumstances, because contriving to frustrate the rules is given in the alternative to there being other aggravating circumstances. So if there are other aggravating circumstances, presumably frustrating the intentions is also an aggravating circumstance. But we're not told what frustrating the intentions might be. We are given a list of other aggravating circumstances, such as failure to cooperate with redocumentation using a false identity, and so forth. So it's very difficult to know quite what is being got at here. Now, there are further problems, I think, with 9.8.2b, because if you look at the rule as a whole, part 9 of the immigration rules, this tells you that most of the rules within Part 9 don't apply to Appendix FM, but some do, and at 9.8 at Part 9.1.1a, so that's at the very beginning of that part of the rules, Part 9. It tells you that one of the exceptions which do apply to Appendix FM are 9.8.2a and 9.8.2c. Okay, now let's just remind ourselves what those are. And 9.8.2a says the applicant has previously breached immigration laws. 9.8.2c says that the applicant has frustrated the intention of the rules, or there are other aggravating circumstances. But B is not included. That's the re-entry ban for a certain number of years. But for me, this begs the question, does any of 9.8.2 apply to Appendix FM? Because the way it's couched is that all three ingredients must be satisfied at the same time, because it goes A, previous breach, and B, outside the time period, and C, frustrating the intention of the rules. So all three ingredients are there at the same time. How can you hive off one of them without the rest also collapsing? Actually, it gets worse. There was a question during my previous talk about whether an application can be refused because deception was used in a previous application. Well, there is provision for that in the new Part 9. And if you look at 9.7, not 9.8 this time, 9.7.2 says that an application must be refused, so it's mandatory refusal, where deception was used in a in the present application. So if you're applying for entry clearance, or indeed leave to remain, and it comes up that you did use deception in the same application, it must be refused. What about previous deception? Well, at 9.7.3, yes. It says that, yes, that leave that you've already got may be cancelled if in a previous application you used false representations, false documents, or false information. But it doesn't say about previous deception. So it's all a bit unclear when 9.7.2 says that an application must be used if deception has been employed in an application. Is it confined just to the present application, or can it also be stretched to a previous application? So it's a bit unclear, and that's a problem, I think, with Part 9. There's also unclarity at 9.8, because I think this is what the questioner was really wanting to know about in the previous talk. 9.8.3a says that an application may be refused, so it's discretionary. An application may be refused if deception was used in a previous application. Well, that's a bit encouraging, isn't it? Deception in a previous application, that could cause a discretionary refusal, but not a mandatory one. So you may not be refused. But this seems to go against 9.8.7F. Now, 9.8.7 gives you the re-entry bans. And I mentioned a bit earlier about the least serious one being a ban of 12 months, where you make a voluntary departure at your own expense. And the most serious one comes at 9.8.7F, that you've used deception in an application. You can't come for 10 years. So it seems that you would have to wait for 10 years if in a previous application you did use deception, and then you may still be refused if you use deception in a previous application, although it's not mandatory. So I think that must be what it means. Otherwise, the two grounds of refusal would be contradictory, because if you must be refused because you use deception and you can't apply for 10 years, you obviously can't apply during the 10 years. And the fact that you use deception would be neither here nor there. So yeah, I think that is a matter of some conjecture. And then just to finish off quickly, the double whammy that I'm referring to, there is a second part to it, and that is the suitability grounds, which can be used instead or together with Part 9. And in particular, the SEC 0.1.5 ground, suitability for entry clearance. This says that exclusion of the applicant is conducive to the public good because, for example, the applicant's conduct, character, associations, or other reasons make it undesirable to grant them entry clearance. So this is a mandatory ground for refusal, and it seems to be interchangeable with Part 9. So an example that I've come across recently in a refusal letter says, Home Office records show you have overstayed, failed to report, and absconded. These are all aggravating circumstances. I have considered the circumstances of your application, but in the light of your character and conduct, so this is SEC 0.1.5, I consider it undesirable to issue you an entry clearance, and I am not prepared to exercise discretion in your favor, although refusal is mandatory. The entry clearance officer doesn't seem to have twigged about that. So there we are. A double whammy can be imposed upon you where the refusal is based both upon discretionary grounds in Part 9 and a mandatory ground under Appendix FM. Well, I hope that wasn't too laborious a run through those grounds of refusal. Now, let me have a look at the Q&As, and I hope I can finish on time, which will be at 1:20 and that should give us plenty of time for lunch. So let's just scroll down here. Oh, okay. First of all, from Adani, the tricky issue which I need clarification on is when does the 5-year period for a residence card holder who has been in the UK before the IP date stop? Does it end on the IP date or extends? Oh, I've been asked to put my video back on. Or does it extend after this date? The implication is that in deportation matters, a person facing deportation may not be able to claim enhanced protection if it ends on IP date, as opposed to running its course for 5 years from the residence card. The assumption is that the EEA regulations have been agreed to govern the deportation. I need to scroll down a bit more, sorry. Just get my cursor in the right place. Oh, that's it. Oh, well, look, if you were in the UK with a residence card, you were supposed to apply for status under the EU settlement scheme. Okay, now you had until the end of 2020 to do it, though that was extended to the end of June 2021 for a grace period of 6 months. And you still had the possibility to make a late application for pre-settled or indeed settled status under the new scheme if you'd already had a continuous period of residence before the end of 2020. Okay, so your residence card would expire, but you would be able to rely on your status under the settlement scheme instead. And when it comes to being eligible for settled status, you could use a period of lawful residence with a residence card before the end of 2020 to count towards the 5 years when you become eligible for settled status. Now, what happened with deportation is that although in other respects, after the end of 2020, you should come under the immigration rules, including Appendix EU, you could still continue to rely upon EU law if you were threatened with deportation for something that you committed before the end of 2020. Okay, so a residence card doesn't really come into it. Now, let's see if there are more questions. Oh, there are. Referring to adult dependent relatives, applying Gen point 3.1. Oh, well, Gen point 3.1 doesn't apply to appendix adult dependent relative because it's now got its own separate appendix. Anyway, the question continues. What are the findings in relation to entry clearance as a visitor? She was not entitled to switch to another category. No, normally she would not have been able to. She was only able to because for a limited time, visitors could switch to another category on account of the coronavirus concession. It enabled them to switch to anything else, including the ADR category. And there was argument in this case I got involved with if that really was the effect of the coronavirus concession. But it certainly was. I mean, the language is plain that visitors were included among those who could apply in country for something else. But of course, not anymore. What is the name of the case related to attending a funeral? Sorry, I was meaning to announce that at the beginning, but I forgot. So thanks for reminding me. Yes, now this case where you can hopefully apply for a visit visa on the basis that a very important family occasion is to be attended, and it actually can engage human rights. This case is called Abbasi. That's A-B-B-A-S-I, Abbasi. And the ECO Karachi, yes, it goes back to a time when there were ECOs in Karachi. And the citation is 2015 UKUT, UK-UT 463. So 2015 UKUT 463. And this is where a presidential panel, the president being Mr. Justice McCluskey, held that it did engage Article 8 in that very close family members wanted to attend the funeral rites following the death of an elderly Pakistani man in the UK. Actually, the question whether this was rightly decided came before the Court of Appeal a couple of years later. And the three-judge court, I think the only reasoned judgment was given by, or the only lengthy judgment was given by Lord Justice Singh, Rabinder Singh, and he said that he thought that Abbasi was rightly decided on its own particular facts, but he stressed that it wouldn't be normal at all for a visit, even a family visit, to engage Article 8, because normally there would be the usual Kugatas principle that there had to be dependency going beyond the norm between the family members concerned. Okay, now there's another question. Will an EU national married to a British national be able to apply for settlement under the EU SS? Now, I take it the EU national has not already got status under the settlement scheme. So I'm not sure if this means an EU national who's in the UK already, or a European citizen who wants to come to the UK. Now, the thing is, if it's a European applying to come to the UK for the first time, she wouldn't be able to use the EUSS because the British citizen isn't here by virtue of the settlement scheme. So it would have to be entry clearance under the immigration rules as a spouse. If she's already here under the settlement scheme, and she gets married to a British national, I think she could simply continue towards the 5-year point where she gets indefinite leave anyway, settled status. If she were to apply for leave to remain on the basis of marriage under Appendix FM, it would take 5 years, and she's probably got less than 5 years to go anyway if she's already here under the settlement scheme. So one more question. I have a case where the father's dependency application was refused for failing to declare a previous refusal and banned for 10 years. His minor children's applications have been refused as well. The ECO said that because they were to travel with their father and their mother is in the UK, she could have come for them. Okay, well, it would still be open to the children to apply separately for entry clearance to join their mother, providing that she is settled or is British. As for the father, so was he to be dependent on one of his children in the UK, or dependent on his wife? Yes, it's a bit unclear. I take it that the sponsor was not his wife, because if she was, then it would have been a spouse application rather than a dependency application. Yes, well, I think the solution as far as the children are concerned would be to make separate applications as children to join their other parent, unless, of course, there's the business of sole responsibility. So that is a problem, isn't it? If the father is prevented from coming because of this 10-year ban. So he's stuck in one country, and if the children are to come, it has to be shown that the mother is solely responsible for them. Difficult if they've been living with their father hitherto. What to do? Possibly a human rights claim could be made if their circumstances in their own country with their father are such that they would be far better off with their mother. And then it could be, you know, an old style paragraph 298 application, application 987, exclusion undesirable because of serious and compelling family or other considerations. That's all I can think of. Oh, it says, sorry, I'm scrolling down again. I'll try and hurry up a bit. Sponsor was wife on a care visa. Oh, I see. Right. So she's working here. And well, I think if the father isn't able to come, then the children can't come either because of sole responsibility. The other thing I said about serious and compelling family or other considerations, I don't think that would apply to people on a work visa. And then just a couple more questions. Can spouses of EU nationals having no status apply under UK immigration law if they got married after the cutoff date of December 2000? No, if they're relying on marriage, it has to have taken place before the end of 2020. Another one, can a Lithuanian national joining another Lithuanian national with settled status, ILR, apply for pre-settled status based on his relationship with the one who has indefinite leave? Well, if the one who wants to join a Lithuanian with settled status here, if they were not living together in a relationship as a partner before the end of 2020, it won't be possible to use the settlement scheme. It's possible for people who were married before the end of 2020 for the one who is living abroad to join the one who's got status here under the settlement scheme. But for people who are not married, they're just partners, they would have to have been living together in the UK, and one of them would have had to get a residence card as a partner in order for them to continue in the UK as partners. And I think that is the lot. So let me just announce, much to everyone's relief, that we've now got a lunch break, and I've run on after my time of 1:20. So I'm just as much to blame as anyone for overrunning. We've got a lunch break now till 2 o'clock. Let's make it 2:05, given my overrunning. And we're going to have a panel discussion after 3 o'clock, from 3:05 for half an hour. So actually anything that we haven't been able to answer, any questions we haven't been able to answer, please bring them up then. And if any of our answers were wrong, please also let us know then. But for now, I'll see you back at 2:05. Okay. Welcome back, everybody. I hope you did have long enough for lunch. And now we come to what is the most topical topic that we're going to be hearing about today, the illegal migration bill. And it's Julian Norman who's going to be telling us about the latest exciting developments from Parliament and what lies in store. So without further ado, Julian, over to you.
Thank you. So I'm going to be talking about the illegal migration bill this afternoon, and hopefully I will be able to share some slides with you. So let's just see if I can do that to start off with. There we go. Is everybody able to see the screen? Hopefully that should now be being shared, and what you should be able to see is a purple slide and not my notes, which will be far less interesting. They're just bullet points. All right, so the illegal migration bill was introduced on the 7th of March 2023. And it has been the subject, I think it's fair to say, of a vast amount of debate. 2 readings in the Commons, then there's been the committee stage and the report stage, then there's been a 3rd reading in the Commons, then 2 readings in the Lords, a committee stage and a report stage, and then the 3rd reading in the Lords took place yesterday, 10th of July 2023. So that means that we don't really know what it will look like in its final incarnation. All we know is that it is in progress, and it will look probably similar, but not the same as the current version. So it was introduced on the 7th of March, and the intention, as we all know, is that it will reduce the number of people who enter the UK without any form of leave in order to seek asylum. The intention is that the crossing of the Channel by small boats now, but there have been other methods, of course. We've seen in previous years people walking through the Channel Tunnel was one instance, and we've had people coming in lorries and so on and so forth. So the intention is to replace those types of unlawful and unsafe routes of entry with safe and legal routes, and the bill makes provision to do both. When it was first introduced, it was with the proviso that the Secretary of State did not think that it was compatible necessarily with the Human Rights Act, and was unwilling to make a declaration that it was. But that issue seems to have largely fallen away. There was some significant debate about that in the Lords, and we know that it is intended now to be compatible with our obligations under international treaties. So I'll just start, in fact, with that provision itself. So if we look at clause 1 of the bill, which, if it's passed, will become section 1 of the Act, look at the original March 2023. We had section 1, subsection 1. The purpose of this Act is to prevent and deter unlawful migration, and in particular migration by unsafe and illegal routes, by requiring the removal from the UK of certain persons who enter or arrive in breach of immigration control. Subsection 3 said, accordingly, and so far as it is possible to do so, provision made by or by virtue of this Act must be read and given effect so as to achieve the purpose mentioned in subsection 1. And subsection 3 expressly said section 3 of the Human Rights Act does not apply to any provision made by this Act. So just to translate that into slightly simpler terms, we have a purpose of this Act. Everything done by this Act should be read in accordance with that purpose. And if it conflicts with the Human Rights Act, this takes priority. So that's the original that was drafted. That has fallen away, and what we have as the latest version is that nothing in this Act shall require any act or omission that conflicts with the obligations of the UK under the Convention for the Protection of Human Rights, the Refugee Convention, and the Conventions on Statelessness, Rights of the Child and Trafficking. So for the purposes of immigration practitioners, that puts it very much back into the ballpark with which we are familiar, on the basis that all legislation should be read compatibly with the Human Rights Act. So let's then look next at process and procedure. And here we're looking at clauses 2 and onwards. And this is 4 conditions which, if they are met, mean the Secretary of State must remove the person. So what are these 4 conditions? Because we are, and do keep these in mind, because we're going to be coming back to these again and again through the bill. But in summary, they are that the person is here unlawfully. And yes, that does mean small boats. Obviously, this bill is very much designed with those in mind. But it also means anyone who's arrived without entry clearance who needs it, anyone in breach of a deportation order, or who entered using deception and so on. So that actually covers people who came here legally, for example, as visitors, or legally in that they had entry clearance, but in fact they were using the visit visa as a method of accessing the UK with the intention of remaining here to claim asylum, because of course to get a visit visa, as you will know from this morning, you must have an intention to return back. So it is quite far-reaching, this provision. The second condition is the entry was on or after the date on which the Act comes into force. Now that's also a change from March, because it was going to try to take retrospective effect, and did not come directly to the UK, including passing through a third country on their way to the UK, and that they require leave to enter or remain and do not have it. So who is that going to cover? And the answer is going to be most of our asylum seeking clients, who will either usually have entered unlawfully, or possibly with a visit visa or so on. And many, of course, will have passed through third countries on the way here, notably France, but people will have come from other countries as well. And requiring leave to remain and does not have it is self-explanatory. So what do we make of that? Essentially, that would mean that the only people who are entitled to claim asylum here are those who enter via newly created safe and legal routes, or alternatively people who are already here lawfully and then who have a surplus claim. And a surplus claim is one which arises whilst the person is lawfully present in the UK. So for example, you are here on a valid work permit or student visa, and the country of which you are a national descends into civil war, or a provision is brought in targeting your particular characteristic, and you become a refugee while you were here, but you were not one when you left. So that is a type which will not be affected by this bill. So let's have a look at that condition, come directly, because this has been a topic of much contention. And of course, we have been here before. We have considered the meaning of come directly. The Refugee Convention itself says that contracting states will not impose a penalty on those who have come directly from the country that they have fled. And we have followed, in the criminal context, we have followed the UNHCR view, which is that directly means that you haven't taken too long about it, that you have started a journey and ended a journey, and that is the directly. Of course, what the authors of this bill would like it to mean is without any transit at all, so no stopping. We may find ourselves revisiting case law which we had thought was settled, because in the criminal context we had Crown on the application of Ademi and Uxbridge Magistrates Court, and Ademi had been convicted of unlawful entry or an offence of that nature, and judicially reviewed that decision on the basis that the Refugee Convention should protect him. And the court held that come directly did not mean came without any stopping time, came without transit, did not pass through any other third country. It just meant that the journey had begun and had ended, but it was one continuous journey, essentially. It's not somebody who had obtained a work permit for 2 years on the way in another country to where they could reasonably have stayed. That was then revisited again nearly 10 years later in AstenJ, which got as far as the House of Lords. AstenJ was a slightly different situation because she was attempting to leave the UK. She was somebody who was attempting to reach Canada and had, in order to claim asylum, and she had passed through the UK on her way to Canada. She was found to have a false document, and she appealed the decision, the conviction, on the basis that, again, the Refugee Convention protected her. She was on her way to Canada to make her asylum claim. The UK was just a stepping stone on the way from her starting point to her final destination, and that she needn't go directly to Canada in terms of not stopping anywhere. It was not a unanimous decision, but her appeal was successful. So Lords Bingham, Hope and Carswell agreed that what the court had said in Ademi was right, but Lords Roger and Mance dissented, and they took the view that the authors of this bill would prefer, which is that directly means without those stepping stones in place. Now, obviously, that is to do with criminal penalty, and inclusion in this bill is unlikely to be regarded as a penalty for the purposes of the Refugee Convention. So I think it would be ambitious to think that this matter is completely settled. Would removal without full consideration of a claim count as a penalty? It seems pretty unlikely, but it's possible. And of course, the fact that those two cases have fallen on the side of directly meaning stepping stones are permitted doesn't mean that that view will necessarily be followed, but it is a strong indication. It would be something that we could rely upon in making that argument. There are some exceptions for unaccompanied asylum-seeking children, victims of trafficking, and of course that means that will make early identification of children and victims of trafficking all the more pressing. So it may well be that it has the effect of us seeing more people who are talking about trafficking rather than fewer. So what's the effect of this? The effect of this is that when the 4 conditions are met, the Secretary of State must declare the protection or human rights claim inadmissible. At that point, the clock starts ticking and the person must be removed within 6 months. Otherwise, their claim has to be considered in the usual way. And the legislation expressly says that a declaration of inadmissibility is not a decision to refuse, therefore there is no right of appeal. There are some alternatives which I'll get to later on, and applications for judicial review or claims to be victims of trafficking are removed from this provision. So it does appear on the face of it to mean that if a person faces a mandatory removal, subject to any suspensive claim, and I'll get to those later, and they apply for a judicial review of the decision, the time for the judicial review seems to be still part of the 6 months. Now, the first thing that I would say there is beware the Hamid jurisdiction. Putting in an application for judicial review simply to run down the clock, and the 6 months is likely to be frowned upon in the extreme by the courts. But it is notable that if you do have a good basis upon which to bring a judicial review, it doesn't appear that that will stop the clock. So that takes us then to removal, because if we find that these claims must be treated as inadmissible and the person must be removed within 6 months, how is that going to happen? And clause 5.1 provides that where the Secretary of State is required to make arrangements for removal, she must ensure that the arrangements are made as soon as is reasonably practicable. So some litigation that I think we will all be looking forward to is a stream of litigation on the meaning of what is reasonably practicable. I did have a look to see if there was anything helpful, because of course reasonably practicable is a term that you see in other areas. There's a vast amount of case law in the field of contract law, where a contract has required that people take action as soon as is reasonably practicable. And the answer is the classic lawyer's answer, I'm afraid. It depends. So at what point the Secretary of State's arrangements can be said not to have been made as soon as is reasonably practicable is something that's likely to be the subject of a certain amount of litigation, and will be, assuming that this provision passes, will be an area in which people will be able to challenge removal, saying, well, you know, you left it 5 months and 2 weeks. That wasn't as soon as is reasonably practicable. And so therefore the decision made is unlawful. And we will obviously have to see where that goes. So where can removal take place to? This does get a little bit complicated. We've got A, B, C, and D. So removal can take place to a country of which P is a national. Obviously, that's going to be quite a worrying thing if somebody's made a protection claim and they're being removed straight back to that country without a substantive consideration of their claim, because there is a risk there of refoulement, which obviously would be contrary to the Refugee Convention. B, a country or territory in which the person has obtained a passport or other document of identity. Now, in reality, this was always going to be an issue, because if somebody has a passport for another territory, then there's no reason that they can't go and live safely in that country anyway. C, a country or territory in which P embarked for the UK, which I think we can infer means that there is a hope that France is going to step up and accept a large number of people. Or D, a country or territory to which there is reason to believe P will be admitted, which at the moment we think means Rwanda, subject of course to any onward appeal from the Court of Appeal, but that seems to be what was intended by that provision there. But there is then a further provision over safe lists and the safe states. So there is a list within the 2002 Act of safe states, and that will be amended by this bill, updated. And if P is a national of a safe state, he cannot be removed to his own country or one where he has residence, A or B in the previous list, if he makes a protection or human rights claim and there are exceptional circumstances. Exceptional circumstances will include where the country is derogating from any of its obligations under the Human Rights Convention, or where the country is an EU member state and is the subject of a proposal initiated in accordance with Article 7 on the Treaty of the European Union. Now, what is that? That is a risk of a breach of values of Article 2 of the same treaty. And Article 2 of that treaty says the Union is founded on the values of respect for human dignity, freedom, equality, democracy, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. If there is a clear risk of a serious breach voted upon by member states, that triggers an Article 7 proposal. So again, trying to wrap that up into something slightly clearer. If somebody is a national of a safe state, they can't be sent to their own country or one where they have residence if they've made a claim and the country is derogating from its obligations, or where there is a clear risk of a serious breach of those values voted on in Europe. Now, in terms of which member states may be the subject of any such proposal, that will be a matter of fact at the time. But it would be interesting to look at whether the country in question is derogating from any of its obligations. That will be a matter of background evidence, probable expert evidence. And that really means I struggle to see how that isn't a human rights claim by the back door, because if you are saying this person's human rights will be violated in one of these safe states because the country is derogating from its obligations, that is still a human rights claim, but with a higher threshold. They can, however, be removed to his country of embarkation or a country to which there is reason to believe he will be admitted. So even if he does make the human rights claim and establishes the exceptional circumstances, C and D still remain. So, and then we've got, if he is not a national of a listed safe state, then he may not be removed to the country of origin or one he has residence, and he may only be removed to his country of embarkation or one to which there is reason to believe he would be admitted if the country is listed in Schedule 1. And that gives a list of states which operates in a very similar way, it seems, to the safe state list. Albania is then on both lists. So to give a worked example there, if the person is Albanian, Albania is on the safe list. So he can be removed to Albania unless he shows exceptional circumstances, which would have to be that Albania is derogating from its rights under the convention. And he can be removed to Calais, where he came over from. And he can be removed to Rwanda, which is listed in Schedule 1. So I'm going to imagine for now that the Rwanda litigation has completed and people can be removed there. If it's not Rwanda, it could be somewhere else on Schedule 1, which there is an agreement with, or that part will simply cease to apply. Let's give another example for someone who is not on the safe list. P is Syrian. Syria is not on the safe list, so he cannot be removed to Syria. He embarked from Turkey with a deceptively acquired visit visa. He can't go to Turkey because it's not listed in Schedule 1. On our hypothetical example, I'm saying he may be sent to Rwanda because that is listed on Schedule 1, but if it were to be the case that that all falls away and there is no onward appeal from the Court of Appeal's recent decision, he can't go there either, which would make a lot of this quite difficult for the government to operate. So there are some restrictions on this, which are quite welcome. They focus on LGBT people. Trans men and trans women must not be removed to Brazil, and LGBT people must not be removed to Gambia, Ghana, Jamaica, Kenya, Liberia, Malawi, Mauritius, Nigeria, Rwanda, or Sierra Leone. South Africa and Albania are not on that list, although I am aware that LGBT people from those countries have been successful in asylum claims. And then nobody can be removed to any country listed in Schedule 1 if the exceptional circumstances of 55B apply to that territory. Now, this again is quite likely, I think, to be the subject of further litigation because it is rather woolly. 55B, it takes us back to the risk of a breach of values of Article 2. Now, when we look at that in the context of member states of the European Union, that requires a third of the member states to vote to trigger the Article 7 process. There must be a clear risk of a serious breach. And if that proposal is either underway or it has been considered and has been triggered, then that for European member states will be a matter of fact. If you're dealing with removal to Italy or to France, is there an Article 7 element of this? We can check with the European Union. It will be clear whether there is or there is not. But what are you going to do when looking at South Africa or Albania or anywhere else that appears in Schedule 1? We would need to show a clear risk of a serious breach of the values of respect for human dignity, freedom, democracy, equality, and so on and so forth. And it's quite difficult to see how that would be argued without recourse to a significant amount of expert evidence. But also it places the first-tier tribunal judge in a position where they have to make a decision applying an assessment that would ordinarily be made only by a large number of combined state authorities. So it's very unclear how that would work in practice. Now, the procedural removals, the person may not be removed unless the proper process has been complied with. And that means a written notice of removal specifying the country, and the claim period for any suspensive claim must have expired, which brings us on to one of the most interesting bits of the proposals in this bill, which is suspensive claims. What is a suspensive claim? There are two types of them: a serious harm suspensive claim and a removal conditions suspensive claim. So when somebody comes in, if they meet the 4 conditions, we remember the 4 conditions from clause 2, they must be removed. Their claim is inadmissible. What can they do to avoid this? And the answer is a suspensive claim. A serious harm suspensive claim is a claim that the person would face a real risk of serious harm if removed to the country specified, such as death, torture, inhuman or degrading treatment, or refoulement. And a removal condition suspensive claim is a person who has been given a removal notice and thinks that they don't meet the removal conditions. So we can well imagine somebody who is a surplus claimant saying, well, hang on, these conditions do not apply to me. There is no question of me having failed to come directly because this claim arose whilst I was already in the UK. And of course, one issue there is that we are looking at a real risk of serious harm if removed to the country specified. So it's not just going to be the country of origin. We're also looking at potentially the country of embarkation or this third country, if that should be workable. The person cannot be removed whilst this process is ongoing. And again, we've got the clock is ticking for these 6 months. So it remains to be seen whether the Secretary of State will have the capacity to deal with these claims within the time. If she can't, then the person's claim has to be dealt with here. Clause 37, the serious harm suspensive claim is not a human rights claim, the legislation says, and so there is no right of appeal. Those of you who have been in practice for a while may think this sounds very familiar. We've been here before. And of course we have, with all of the litigation over what amounted to a human rights claim that attracted a right of appeal when the 2002 Act was amended so as to remove the grounds of appeal other than Human Rights and Refugee Convention. So we know from the cases I put out there, AT by Hinger and Al-Gambari, what are the minimum elements of the Section 113 human rights claim. And these were said to be a claim not to be removed from the UK, an assertion of facts that could constitute an existing or prospective private and or family life. And this was to do with Article 8 specifically, but you could see how it would also apply to Articles 2 and 3. An assertion that removal will interfere with that. And that was all that was necessary for a human rights claim to exist. So it is difficult to see how you would argue a serious harm suspensive claim without it also qualifying automatically as a human rights claim, which would attract a right of appeal. So it seems that at the current stage that this bill is at, the Secretary of State thinks that it can simply be asserted that these are not human rights claims, and that will have the effect of preventing them from being human rights claims. But we do know from the previous case law that may well prove to be unduly optimistic on the part of the Secretary of State. Other issues with the suspensive claims, time limits. Actually, I'll look at assurances first. The Secretary of State must take into account any assurances given by the receiving state's government. That's interesting because that brings immigration into line with extradition, where a government is able to give an assurance. So if you've got a country where there is an overcrowding problem in some prisons, the government of that country can give an assurance and say, well, if this person returns to us, we will promise not to keep them in XYZ prison. We will make sure they are in open conditions at ABC prison. So it seems that that's anticipated here. Time limits are going to be absolutely rigorous. Once a person arrives and is considered to qualify for this scheme at all, so meets the 4 conditions, they have 8 days, including the day on which they are given the third country removal notice, to put in a claim. The decision period is then meant to be 4 days. The requirements are also rigorous. There must be compelling evidence on the prescribed form along with the prescribed information. And if you fail to get sufficiently compelling evidence in, the Secretary of State may certify a suspensive claim as clearly unfounded. So that's going to be quite difficult to do, quite frankly, and practitioners will need to be really on top of their deadlines and timeframes, and be able to identify as well any difficulties with individual claimants. Are they going to need a period of rest and recovery before they're even in a fit state to give any evidence? If so, that will need to be made as a separate submission. So if a suspensive claim is certified as clearly unfounded, you can't appeal it, but it is possible to apply to the upper tribunal for permission to appeal the certificate. Does this sound very much like a judicial review of a clearly unfounded decision? Absolutely it does, but unlike a judicial review, it does not come with an accompanying right of appeal to the Court of Appeal. The upper tribunal is also given the power to grant or refuse an application to bring a suspensive claim outside the 8-day period. So if you are dealing with somebody who hasn't been able to get their evidence together, and you're trying to bring the claim a bit too late. It's now the upper tribunal which will deal with whether or not you get that relief. But one thing that does seem uncertain at the moment is whether, if somebody applied for permission to bring the suspensive claim outside the period or to appeal the certification, if that were refused, either on the papers or on an oral permission hearing, would it be possible to JR that, notwithstanding clause 47, which says the decision is final? It's difficult to see whether that would go anywhere or not. But I think if it were to be challenged, as of course did happen with CART judicial reviews, albeit those have been pulled right back now, any test case would need to be a solid one. There would need to be good grounds to pursue that. Right, just look at how we're doing for time. Yep. Now, the Act also makes provision, quite extensive provision, for detention. I think we may have gone too far. Here we go. There is a wide provision for detention if the immigration officer suspects that a person meets those 4 conditions pending a decision. And if they do meet them, then pending removal or pending a decision to grant leave. So a person may be detained, firstly, whilst the officer establishes whether they meet the 4 conditions. Once that has been established, then pending a decision either to grant leave or to remove them. There is an exception for victims of trafficking, and I believe as of yesterday, there is also a reduction of the 28-day time limit for children and for pregnant women. So clause 12 provides for length of time. A person liable to be detained may be detained for such period as, in the opinion of the Secretary of State, is reasonably necessary to enable the examination or removal to be carried out. And this applies regardless of whether there is anything that for the time being prevents the examination or removal from being carried out, the decision from being made, or the directions from being given. So it seems that we have 2 potential bases on which this is going to be challenged. The first is, well, what does reasonably necessary mean? And again, it depends. And to what extent the opinion of the Secretary of State is going to be overtaken by the opinion of the courts. And then this provision that it applies regardless of whether there is anything that prevents this from happening seems, in my view, unlikely to withstand a challenge, because it's just such a far-reaching provision. It rules out any set of circumstances or situation in which that detention could be waived. It is tempered by clause 12.7. None of the amendments permit detention that is inconsistent with the following principles. There must be an intention to remove and can only use the power to detain for that purpose. The person being removed may only be detained for a period that's reasonable in all the circumstances. And if before the expiry of the reasonable period, it becomes apparent that the Secretary of State will not be able to effect removal, they must not seek to exercise the power of detention. This appears to be in total conflict with the earlier provision about whether there is anything that prevents the examination or removal from being carried out. And the Secretary of State must act with reasonable diligence and expedition. Time limits. Clause 13 gives the Secretary of State 28 days in which no bail application can be made and no judicial review can be brought. During that time, the powers of either the immigration officer or the Secretary of State are not to be regarded as having been exceeded by reason of any error made in reaching the decision, and no application for judicial review can be brought. Although that is tempered a little bit by saying it doesn't apply if there is a question raised over whether or not they were acting in bad faith or in such a procedurally defective way as to amount to a fundamental breach of the principles of natural justice. That is still quite a high threshold. And again, I think there is likely to be some challenge to the idea that the Secretary of State cannot commit any sort of, cannot exceed her powers in any way or make any error for 28 days. And one can still apply for a writ of habeas corpus. So there is a bit of a blast from the past that fell away really 20 years ago or so, when it was overtaken by Article 5 in most cases, but it is still possible to apply for a writ of habeas corpus, and that is what is suggested there. So modern slavery, covered also within the bill, removes the rest and recovery period, and it removes the requirement to grant even a few weeks of leave to remain. Although it doesn't apply if that person is cooperating about criminal proceedings and needs to remain for that, or if the referral for reasonable or conclusive grounds decision is still pending, or if the exploitation took place in the UK. And of course, we know that victims of trafficking do fall outside many of these provisions. So that means that those are less far-reaching than they could have been. I'll go to future repercussions. I think I've still got 5 minutes or so left. This is quite a serious one because by virtue of clause 27, a person who has ever met these 4 section 2 conditions must not be granted leave to enter or remain unless it's limited leave to an unaccompanied child or victim of trafficking, and they must not be granted entry clearance or an ETA. So essentially this imposes a ban on anybody who has ever met those section 2 conditions, and it's permanent, unless they've already been removed and failure to grant would contravene the UK's obligations. So rather like the suitability requirements, the grounds for refusal, some of them don't apply to Appendix FM. It seems that this would be similar. Clause 28, a person who has ever met the 4 conditions cannot be eligible for citizenship, and that includes minors. It also includes applicants for British overseas citizenship and for subjects, unless there would be a breach of the Human Rights Convention as a result. So for people who do meet those conditions, these are very far-ranging repercussions. This is not a situation as it is at the moment, where somebody who's entered unlawfully can leave the UK, apply for the proper visa and re-enter. They are essentially subject to a lifetime ban. There are also some provisions in here for technology. So clause 15 looks at electronics. This confers powers to search people liable to be detained and to search for information stored on an electronic form. It provides the power to seize and retain, to access, copy and use information stored on electronic devices. That is very, very far-reaching and may well be the subject of an Article 8 privacy challenge. There is also, although I'm afraid I don't have time to go into it here because it's quite lengthy, there's a potential challenge to the text itself. It's based, I think, on RIPA, which has very similar provisions in a criminal context. Clause 52 and age assessments, the court must determine any challenge to age assessment on the basis that age is a matter of fact to be determined by the relevant authority, and may grant relief only if the decision was wrong in law, proceeded on information incomplete, misleading, or otherwise so seriously misinformed that no reasonable decision maker would have relied on it. That does seem to be an attempt to really raise the bar in terms of age assessment. And we will have to look at what effect that has on existing case law and whether or not Merton compliant age assessments are still going to be relevant. Clause 53 provides the power to make provision about refusal to consent to scientific methods. It will be subject to regulations, but it will be an adverse inference issue, essentially. So it updates Section 8 of the Asylum and Immigration Treatment of Claimants Act. And with Clause 53, this is somebody who refuses to consent to scientific methods of age assessment. An adverse inference may be drawn, but it would be really interesting to see what would happen if the person were then to instruct an expert to say that the scientific method sought to be relied upon is quasi-scientific junk. That's slightly preempting what type of scientific method might be suggested. But age assessment is notoriously difficult. And it's easy to foresee a situation where we would end up with a similar degree of confusion as happened with the language assessment of asylum seekers. Who are the experts? How are they operating? And so on. And then Clause 58 amends Section 8 to include failure to provide to an immigration officer any information or anything else required to access any information stored in electronic form on a thing in the possession of an immigration officer that was found on the claimant or appears to have been in the possession of the claimant. This is the give us your phone requirement, and an applicant can be disbelieved or less weight attached to their credibility if they don't cooperate by handing over their phone. And again, we've recently had case law that says, well, that was excessive. The information can perfectly well be obtained through the examination by a solicitor, for example. Finally, and I think we've just got 2 minutes to deal with them, safe and legal routes. There would be a cap on the number of entrants, but the Secretary of State, if this bill is passed and if it is made law, it gives the Secretary of State 6 months to produce a report on safe and legal routes, and then a further 2 months to make regulations specifying additional safe and legal routes. So hopefully this will end at least with some safe and legal routes being made available. But how many there will be, how that would work remains to be seen, because it's one thing providing that type of a facility from somewhere like Ukraine, or Afghanistan for that matter, where it is possible, more possible in Ukraine, to get somewhere and make the application. But what would you do if, for example, you are wanted by the state, or if you are an LGBT person in Uganda? Are you really going to approach an immigration officer, even at the British Embassy, and disclose the basis upon which your future claim will be made? So that will need some tweaking, but it is reassuring to know that it is being envisaged. But one thing that might be an interesting challenge would be to the implementation of any of these more difficult or more intrusive provisions prior to the establishment of those safe and legal routes. So if the 4 conditions and the removal and the inadmissibility were applied to anybody in the 8 months that this safe and legal route reporting was to be done, would a claimant theoretically have a challenge on the basis that, well, you haven't put in place any safe and legal routes yet. What was I to do? I don't know. I can't forecast whether that would be successful or not, but it might be an interesting angle. So thank you very much. I think that brings me pretty much to the 2:55 point. So I will stop sharing my screen, but my contact details are there. Let's see.
Well, Julian, I'm very impressed by your punctuality, and you managed to get it all in within the time allotted. So very well done. And that really was a very interesting survey of where we are at the present time with the illegal migration bill. It's an awful lot to take in, but you've obviously mastered it yourself. That was very impressive. And will you be able to stay for the panel discussion?
Yes, I will be. So I look forward.
That's great. So I'm sure there will be some questions for you based upon your talk, as well as upon the other talks, or indeed any other matters that members of the audience would like to raise. So we'll have a 10-minute break then, and we'll reassemble at, well, it's meant to be at 3:05. Let's make it 10 past to give you enough time for a proper cup of tea or coffee. So we'll see you back here then at 3:10. Thanks very much. You've had time to drink yours. Oh, hello again, everybody. Here we are back again, this time for the panel discussion. So we've got so far, we've got Julian, and we've got Samina, and we've got Sarah. So I think we're actually now a quorum for the panel discussion. Oh, well, Lawrence, I think there you are. You're very welcome to join our panel discussion. The more the merrier.
I might just observe, but we'll see.
Fair enough. Yes, because I'm sure there'll be questions about talks that have already been given. And we probably didn't have time to answer all the questions that were waiting for us in the Q&A box. So I think there was one, perhaps I could start the ball rolling, because there was one I didn't get round to in the Q&As. So let me just take another look. Sorry, just trying to get my cursor to work. Oh dear, it doesn't. Oh, here it is. Yep. Yes, here it is. Sorry about the delay. Can EU nationals with pre-settled status marry someone without leave? And do they have to meet the financial requirements? Well, I think you're talking about an EU national who wants to marry somebody who's here. Yes, somebody here without leave. They can do it. I mean, they can get married, but it won't be under the settlement scheme. The person who is here without leave and whom they get married to, and they would have to get well, they would have to go to a marriage registrar and be given the go-ahead by the Home Office. But anyway, if they do get married, the application for the person here without leave to stay on the basis of marriage would be under Appendix FM. So there would probably be an EX.1 refusal saying that that there wouldn't be insurmountable obstacles to them living outside the UK. But yes, it could be done, but not under the settlement scheme. And then the next question, well, this is about deprivation. So really that's Samina's baby, if you'd like to answer that one, Samina.
So I just read it, and it says I'm going to say answer live so everyone can see it. But it's is it possible for a person to be deprived of British nationality who's currently on the 10 years parent route to switch and apply for ILR under the 10 years long residence? They've been living in the UK for about 23 years. So I think that's kind of a confusing question, because it sounds like they haven't got citizenship yet. So I don't know whether someone's talking about them having citizenship sometime in the future. If that's the case, then it's unclear under on what basis anyone would be thinking about deprivation, unless there's they fall within one of the criteria. So I don't know if anyone wants to clarify. The person hasn't named themselves, they're anonymous, but if they want to clarify that. There was another question which had been asked right at the end of my session, which I said I'd come back to, so I can answer that in the meantime. And that was in relation to serious crime. I think someone had raised the issue of serious crime, and whether CHIMI would apply to those situations. And so just looking back at the guidance that I flagged up, the new Home Office guidance, I think if you look at pages 9 and 10, it is something that falls under the remit of section 42, conducive to public good. So it falls within that. And when you look at CHIMI, the very first line in the head note says that the guidance in CHIMI will consider both section 42, or the structure ought to be followed, with reference to section 42 and section 43. So CHIMI will apply. And one of the cases, the leading cases, was the case, I think, or not leading cases, but one of the first cases considering that, where some guidance was given, was the case of, I think, Ahmed was at the Rochdale cohort, and then there was Aziz after that. So there's quite a few cases on serious crime, and the individual who asked perhaps can look at those cases for some guidance.
Right. Now, have we actually got to the end of the Q&As? There don't seem to be any following that one from the anonymous attendee about the 10-year parent route. Oh, here's one in the webinar chat, not in the Q&A. Shall I just read that out? P, a person P, no doubt, obtains a British passport and has renewed about 3 times. Before P was granted the British passport, P was interviewed. The Passport Office now states that P is not entitled to the passport and wishes to revoke the passport. P was asked to produce further original documents from parents, but parents are dead. Where do we go from here? Ooh, well, I think we need a bit more information to be able to answer that.
Yeah, I mean, it comes, I'm happy to just chip in, but to confirm the same, Richard, we do need more information. It happened, I got a brief inquiry that didn't lead to anything last year that sort of had a Windrush element to it. So there's a distinction there in terms of the British nationality and the deprivation sort of context. Passport isn't confirmation of a person's nationality, it's a travel document. So it has happened many times that persons are issued passports when they're not necessarily entitled to those. So it might be that there may be some complex sort of historical nationality stuff to delve in, Windrush, that type of situation. So yeah, instruct somebody specialist in nationality law is what I would say. And many of us certainly in chambers do advise on that. So, but it would be a question, and the Passport Office do get it wrong sometimes. So it is a question of just looking at that, the basis of their decision, and then trying to track that back.
I was just going to highlight one other thing, because the issue of the issuing of passports is at Her Majesty's or I should say His Majesty now,
Mhm.
there is a ministerial statement, I think, with reference to that. So in a decision where they don't issue a passport, they will refer back to that ministerial statement, and you'd have to, if that's the reason for it, you'd have to look back to that ministerial statement.
Right.
As Sarah's flagged, it's a very specialist area, so.
Yes, indeed. As Sarah says, the passport office can get it wrong. And I think a lot of lay people confuse having British citizenship with getting a passport, but the two are actually different. No, have we got any further questions? I think that there might be some now in the Q&A that have just come in the last couple of minutes. Let's take a look. Oh, I think this is more information from the previous questioner. Person no longer holds British nationality, but did in the past. So for some reason, that person lost his British citizenship, but does have leave to remain and is on a 10-year route to settlement as a husband. And the question was whether he could switch to the 10-year long residence route. Well, it's up to you, actually. If you've lived in the UK lawfully for 10 years, you can ask for indefinite leave under that 10-year rule. That may be quicker than waiting for the other route that you're on to get you to the indefinite leave stage.
It'd be subject to the conduct provisions, though.
Oh, yes.
So, you know, the reasons why they were deprived in the first place could just come back.
Yes, yes. Oh, well, at least he could go on to get indefinite leave, probably. Though even that could be refused on suitability grounds or conduct, character, or associations.
I was
yes,
just
not
going to say,
guaranteed.
Richard, I might flag the case of Musilja, which was in my, not Musilja, it was in my talk, and that.
Oh, Muslia, that one?
Yeah, it was the one right at the end after Slayman. So that talks about ILR and the revocation and you know, where there's conduct which they find fraudulent or material concealment of facts, then they can revoke ILR on that basis. So conversely, they may not grant the ILR on that basis either. So,
oh, well, that's useful to be reminded of. Thanks. Now, there's something else coming up. Yes, here we are. Can one be granted an exemption from taking the Life in the UK test after applying for a waiver? Ooh, a waiver, oh, KOLL, call, yes. After applying for a waiver from call, if they have passed the B1 test. Well, I suppose they can apply for a waiver if they've got medical evidence that they're unable to sit the test for some reason. Though if they've passed the B1 test, they must be fairly okay mentally, it would seem. Yes. So applying for a waiver from the knowledge of life test, although one has passed the language test, well, it's always possible to apply for an exemption, I suppose, but there would have to be some kind of medical evidence, wouldn't there? Yeah, I think that's it. Any other thoughts?
No, I agree. Yeah.
Okay.
Check the guidance. The guidance does set out the type of exceptions they would apply, wouldn't they?
Yes, yes. Yeah, I should imagine the exceptions would be pretty similar for both the language test and the call test, the Life in the UK test. Okay, well, now here's another one. A person P was married on the 18th of March 2016 to an Irish national, commits a crime, and applies for settled status on the 18th of March 2021. Okay, so after 5 years. The Secretary of State says can't get enhanced protection because not up to 5 years before December 2020. Yes, the implementation period date. Is this right? Oh, well, applied for settled status on the 18th of March 2021, having been married for 5 years. And this is too early, according to the Home Office. I think the time would start to run from when the person got a residence card as a spouse.
From marriage, because they're
EEA.
married, I think, right?
Yes,
Yeah.
married an Irish national in March 2016, and applies 5 years on in March 2021 for settled status. We aren't told if and when a residence card was issued under the EEA regulations. Just as applied for settled status.
I think the next one says, the next question, there's more to it. The second part is accepted the 2016 regulations applied, and he applied for settlement before the June 2021 deadline. I think that's kind of, sorry, my view is kind of, it's a little bit complex in that it sounds like there's a crime committed pre 2020, December 2020, but they don't get permanent residence or the 5 years until post implementation, which is 2021. So can they claim that under the regulations, and I might be trespassing on what Lawrence is going to be talking about? No, okay.
Not at all. I'm learning from you, Samina, so you keep going.
So can they claim that he would be entitled to enhanced protection? I think it's arguable, but it's quite complex, isn't it? Because
the crime's committed a bit, doesn't it?
Well, I think in the second part of the question, it's premised that the 2016 regs, as in the EU law deport regime, applies. I think that's how I understand the two questions.
But he's not going to get his 5
but
years.
It's whether the enhanced protection applies. So it has
committed in between year 1 and year 5, I would say.
Well, whether the crime is committed before the end of the TP period is one factor to apply the EU law deport regime, right? And it's whether it's on grounds of public policy, etc., or whether it's serious grounds through the enhanced protection if the person has PR. The question, I think the question is whether PR is acquired post TP period and whether that can then give that enhanced protection. And as may have been obvious, I don't think we know the answer.
I think it's arguable,
all up for grabs, but certainly argue it. But get someone beefed up in EU law, which obviously we all are, despite not knowing the answer.
If we're talking about the enhanced protection that's acquired through 5 years residence, the enhanced protection against deportation, the 5 years must have been acquired before the offence was committed. And I can see it from the person who asked the question, saying the crime was committed before 2020. So if the marriage was only 2016, then there still has to be serious grounds there still has to be public policy grounds, and there must still be a present threat to the UK, and not just based upon the criminal activity. So the usual provisions of the regulations, but you're not going to get your serious policy grounds in your enhanced protection because they've only had their residence card for 3 or 4 years at the date of offence, or the date of conviction is the relevant one. I've had something similar recently.
Now we've had a couple of contributions. One says the time begins to run from the date of the marriage. The crime was committed before 2020, and the EEA deport regime was agreed to apply. Well, this chap is subject to deportation. I mean, surely he wouldn't be entitled to settled status at all, would he, if a crime leading to deportation or a deportation order was committed before reaching the 5-year point?
See, the person is saying he has a right of permanent residence, but I don't, unless he acquired his right of permanent residence prior to the marriage, or somehow
with a mix of durable partnership and marriage, maybe. I don't know if they had a residence card before.
No, you're not allowed to combine those 2 periods. So unless this is, I don't see that he does have a right of permanent residence.
He would already get the enhanced. Yeah, if he had, he would already have the enhanced protection, no?
Yes, exactly.
Permanent residence.
Unless it was disputed by the Secretary of State.
But it's very different with the EEA regulations. It's not like the 10-year rule where you can add the bit, the fact that you've been living here, if you subsequently get leave to remain, you can add the bit before onto it for the purposes of acquiring your 10 years. If he's been living here on any other basis prior to the marriage in 2016, it doesn't count. It has to be living in accordance with the regulations.
Yes, now the same person has added regulation 10, or is it 15? I think he's changed it to 15. Regulation 15 EEA allows, and he spent 5 years with a residence card.
Well, there are not 5 years between 2016 and 2020. There are 4 years.
Yeah, he might have had the residence card issued for 5 years, but whether he's acquired the permanent residence as a result of his treaty rights and residence rights is a different matter, and as Julian points out. But I mean, it's as we can all see, it's complex, and instruct Julian because it sounds like she knows what she's talking about.
Or don't, because I'm not I agree. No, I'd be happy to talk about it. I'd be very happy to have a chat about it after the seminar is concluded. You're very welcome to email me and I'll happily look at it. But I think he would have needed his 5 years with a residence card prior to the date of conviction.
Right, well, we've got some other questions. They have started appearing in the Q&A. So let's see. Here's one. Should a client pay the NHS bill sent to her for receiving treatment whilst waiting for a decision? She is a mother of a British child with 2.5 years leave, but applied for renewal 10 days after the expiry of her 2.5 years leave, I suppose. Treatment was received during the 10-day period before applying for renewal. Okay, so there was a gap of 10 days before her leave expired. Sorry, after her leave expired, before she applied for further leave. This would be a period when, despite your leave having come to an end, you could apply for further leave and it wouldn't be counted against you, as it were, as being a period of overstaying. But actually, she was here without leave during those 10 days. So does that mean that she was liable to pay for treatment on the NHS during that period? In fact, because she was here without leave during those 10 days, she wouldn't have got Section 3C leave, would she? I mean, because her leave had run out before she made the application for further leave.
And it's all tied up with the NHS regulations, the charging of any regulations. Those were amended to redefine ordinarily resident as a person who doesn't have leave. Again, immensely complex. Maternity action, Regina, if you haven't approached them before, are a good start. They have some materials there. They've campaigned heavily on this issue. They've taken cases. Yeah, that's as far as I certainly can contribute on that.
Right. Oh, no, here's another one. Home Office incorrectly issued an unmarried partner visa to an applicant who applied for a fiancé visa. This was not corrected out of country, and the applicant entered the UK. Is it still possible for the person to marry her fiancé, or would the mistake need to be rectified first? And how can this be achieved in country?
This is an interesting one, because I think that they have, not of their own fault at all, but I think that they've actually been given quite an advantage by the Home Office, because what they wanted to do was apply for a fiancé visa, which would allow them to come in, get married, go away, and apply for a spouse visa to come back in. And what they've got is an unmarried partner visa, which allows them to get married and remain on the spouse visa. So I think she's quite entitled to get married. And then I think what I would do would then be to apply for the spouse visa in country and say, you know, she applied for a fiancé visa, she's been given an unmarried partner visa, so be clear about what it is, but say, given that she is already in this route, please confirm that you're happy to make the switch in country.
And I think there shouldn't be a problem switching like that in country. I mean, you're not, it's not a completely different student to spouse or anything like that. But, you know, it's quite close in terms, and they've made the mistake.
Well, actually, it certainly redounds to her advantage. If she had been granted a fiancé visa, they cost the same as a spouse visa. But once you're here, you've got 6 months in which to get married, and then you have to apply to switch to the spouse route. So you're paying twice over. So you're paying again £1,048. You've already paid it for the fiancé visa, but you still got the 5-year route ahead of you. So you pay then for leave to remain as a spouse. But if she's in the country already with 2.5 years leave to enter as an unmarried partner, well, she could just accept that. She can still get married. You know, she doesn't have to be an unmarried partner all her life. She can get married. And I think if that happens, would it be the case that you could, when you come to the 2.5-year point, you can apply for further leave as a spouse rather than as an unmarried partner? I mean, it's all in the partner route anyway, whether you're married or unmarried. And so maybe best just to say nothing and accept the status quo. Right, well, let's see what's next. Okay, ILR on long residence grounds was refused because Section 3C or 3D leave does not extend when a leave to appeal application is pending in the Supreme Court. Section 104, 2A of the 2002 Act essentially says that an appeal is finally determined in the Court of Appeal. My question is, if an appeal is successful in the Supreme Court, then how can the Court of Appeal's determination be final?
Can I just say that's a really complex?
Yes.
And I've come across it in long residence cases, but it is complex. It is a matter of construction. And I think unless anyone else can really delve into the construction issues right now, it's going to be something which probably needs some real...
Yeah. And Mr. or Mrs. Anonymous Man, you've got some beauties for us today.
Oh, yeah, that really is hard, isn't it?
Mm.
Yes, it's not something that any of us can answer at the drop of a hat. No.
I think just as a matter of pure pragmatism, presumably you'd apply for injunctive relief in the from the Court of Appeal when you applied for permission to the Supreme Court, saying please extend or requiring the Secretary of State to grant discretionary leave whilst this matter is dealt with, or something like that.
Again,
It's
Mr.
very
Anonymous, instruct Julian.
Yeah. Yes, of course, it's not easy to get permission to appeal from the Supreme Court.
No.
It's the application is pending in the Supreme Court, so presumably the Court of Appeal refused to grant permission themselves. Yes. Yeah, I think probably Julian's advice is the best there is. Oh, okay. Well, let's see what's next. Oh, it's Regina again.
Identity being revealed of Mr. Anonymous. Thank you,
right.
Ashraf.
Okay. Well, let's just do Regina first. I applied for indefinite leave to enter. I applied for an indefinite leave to enter visa for a child whose father is British and mother in the UK had a spouse visa. He was granted 2.5 years leave to remain instead of indefinite leave to enter. Is that right? Well, if hang on a bit, if the father was already British when the child was born, then the child would automatically be British and wouldn't need leave to enter. So unless the child, if the child is the natural child of the British man, then he'd be British by descent if born abroad.
Or if there were certain circumstances that existed, they would be able to register as well, pre-entry, so yeah, or even post-entry, depending on what the facts are of this case.
Yes. Oh, well, yes, it could be that the father himself is British by descent, and then the child born abroad would have to be registered as British. But provided the child is still a minor, that could be done. Yes, and the father is now in the UK.
Richard, just keeping an eye on time, I think we may be close or over Lawrence's start time.
Oh gosh, you are right. I was getting carried away.
We can easily get carried away. Lawrence is remaining very polite though, so
yes.
I just thought I'd flag that for you.
I think we will have to leave it at that for now. We haven't answered all the questions, but we can't go on indefinitely. So we now come to our last speaker, Lawrence Youssefian, also like the other speakers, except for me, from Goldsmiths Chambers. So they really are hot on these webinars. And he's going to tell us, a roundup of criminal deportation appeals. So without any further ado, over to you, Lawrence.
Thank you, Richard. Thank you. I'm going to figure out a way to share my screen. I suspect that's what I'm supposed to do. Can you just tell me if you can see this and everything is fine before I start?
Yes, it's all good.
Perfect. Thank you. So, hello, everybody. You can see me, I trust. I'm in Nottingham Court, so that's why my background looks like I'm held in a prison cell. So my name is Lawrence. As you heard, I'm a barrister at Goldsmith Chambers. Today, I'm going to present sort of an overview of deportation appeals with a specific focus on Section 117C of the Nationality, Immigration and Asylum Act 2002. This is the provision. I trust you would have come across it by now, at least heard of it by now, if you haven't already had to interact with it extensively in the course of your work representing clients and so forth. What I'm going to try to do is really to go through the most important aspects of the Section 117C provision, because most people are now going to be caught out by this provision. And that's because EEA nationals, whilst historically they would have been considered under the 2016 regulations, as a result of Brexit, and here oh, I think I'm getting feedback. I think it's just Richard's mic gone up by accident. But I'm going to continue unless it becomes too distracting. Sorry, I lost the trail of my thought. Yes. So in relation to the withdrawal agreement, as a result, now, if the conduct, that means a criminal offense, was committed before the end of the transition period, i.e. 11 p.m. 31st of December 2020, then you would still be covered by the what I would say is a far more lenient and favorable regime considering deportation. If, however, the criminal offense was committed after December 2020, even if you're 31st of December 2020, even if you're an EEA national, you would come under Section 117C. You won't get the help of the 2016 regulation. So increasingly, more and more people are going to be caught out by Section 117C, and that's why familiarity with this provision is going to be extremely important going forward for those who are doing or are thinking of doing immigration deportation appeals and cases. So here, before beginning, I thought I'll just set out a very basic example structure of how to present your deportation appeal, whether orally in court or if you're doing written representations. It's not a extremely sophisticated structure, but it gets the job done. This is actually a structure that I use in court often, and it really helps. One of the reasons I've decided to set this out actually is because I've seen many cases, written representations to the Secretary of State after a stage 1 deportation decision with representations made. And just because one doesn't satisfy one of the exceptions, whoever's drafted the representations decided to not address the exceptions. But in my experience, you certainly should address both exceptions, and we're going to go through that in a moment, but definitely address both exceptions, that each provisions of the sub-provisions of the exceptions, because as I've cited, CI Nigeria, this is a Court of Appeal case, full citations in the next slide. It's important, it's going to be relevant to the very compelling circumstances test. So the extent to which you're able to satisfy the exceptions is still relevant. And therefore, even if, for example, your client hasn't lived in the UK for more than half of his or her life lawfully in the UK, I would suggest that you still go through the social and cultural integration and very significant obstacle to integration into their home country, because that's going to be relevant under Section 117C anyway. So this is just a broad structure that you may wish to adopt. If you come up with a better structure, feel free to email me and I might use it. So the exceptions. Exception 1, private life, and I've set out the exception here. So there are 3 separate elements that you have to satisfy all of them. It's a conjunctive provision. So, and we're going to address it, we're going to deal with it step by step. So there's 3, A, B, and C. A is to do with whether the person has lawfully been resident in the UK for most of his or her life. So first of all, what does it mean, lawfully resident? This was a question that troubled the Court of Appeal in CI Nigeria quite a bit, but the eventual conclusion is that you simply look at the person's legal status at the relevant time. So for example, if you're granted immigration bail pending an application or you're on temporary admission, that doesn't count, because at that particular time, your legal status is not that you're lawfully in the UK, simply that your presence in the UK is being tolerated, which is not the same as being lawfully in the UK. So as a rule of thumb, you're looking at the person's legal status at the relevant time, except if an asylum seeker makes an asylum claim and there was some delay, or even if there isn't a delay, let's say you make an asylum claim in 2003, and that claim is successful in 2005, the period of lawful residence begins from the time you claimed asylum, because recognition as a refugee is confirmatory, it's not declaratory, in the sense that from the time you satisfy the Refugee Convention, you can't be removed, and it's just confirmatory. So I've cited SC Jamaica, which held at paragraph 56 and 57 that if an asylum claim is successful, you look at the period of lawful residence begins from the claim of the asylum, from the time asylum claim was made. And in CI Nigeria, again, paragraph 44 and 48, the Court of Appeal said that SC Jamaica is authority for that, and it was binding on CI Nigeria. So that's the question about lawful resident. Basically, you look at the person's legal status, except if they're an asylum seeker whose claim has been successful. Then the second question, or the point that you may also wish to consider, is section 5.1 of the Immigration Act 1971 specifically says that if a deportation, I'm paraphrasing here, but it says if a deportation order has been made, then that invalidates any leave. And often what happens, if you've done deportation appeals, you will know what will happen is once a decision has been taken, they will also issue a deportation decision. And then there'll be months, if not a couple of years, or at least a year, before an appeal is heard in relation to that, in relation to the human rights claim that resulted from that deportation decision. And in the case of Tirabi, it was held that the invalidation provision under section 5.1 of the Immigration Act 1971 is to be ignored. So if you had indefinite leave to remain and the Secretary of State takes a decision to deport you and issues a deportation order, by the time of the appeal 3 years later, you can still count those 3 years as part of your lawful residence. This is a point that I've heard the Secretary of State argue the opposite a couple of times in their review and in court, represented by counsel, no less. And so it was necessary for me to bring to the Secretary of State, the representative of the Secretary of State, their attention that Tirabi said otherwise. So this is a good case to bear in mind when you're concerned with a person's lawful residence in the UK. Another thing which might interest you is, well, does lawful residence have to be continuous? We're quite used to things having to be continuous in the sphere of immigration law. But first of all, interestingly, there's no, as far as I'm aware, there's no authority that deals with this, whether lawful residence has to be continuous. What I did find is paragraph 54 of CI Nigeria. In that case, the Court of Appeal considered that the appellant was totally resident for 2 periods, and they combined that 2 periods and said this is his lawful residence, total lawful residence, even though there was a gap in the middle. So at least on the face of it, it seems, based on CI Nigeria paragraph 54, it seems that lawful residence does not have to be continuous. And actually, I had a case in the FTT where I relied on this point, and the court accepted my argument, and we couldn't show more than half life of lawful residence continuous. There was a huge gap in the middle, but the judge accepted that you can amalgamate the two. And so that we were successful on that point. Well, actually the whole appeal, but on that point as well. And finally, this is quite trite, but I just thought I'll put it in there in case. More than half means most of claimant's life, because this is most of C's life, means more than half of your life. Okay, and so often what you have to do, just before I finish up on this part of the exception, what you have to do is you actually have to calculate sometimes to the day. I've had to do that, and sometimes we've been 4 days over the threshold, which was really great. But sometimes you'll find yourself, you're like 8 days out of the threshold or something. So that's something that you might want to address or bear in mind when you're calculating more than half. Right. The second point, so now we're here, B, socially and culturally integrated in the UK. I'm so sorry that this is so small. I got overzealous in cramming as much information as possible. I hope you can see it. So first of all, this is a point that comes up in deportation appeals always, at least for me. I don't know what it is, but for me, the Secretary of State is refusing more often than not to accept that my client, most archetypal case where my client's been in the UK since age 2, commits 1 or 2 offenses, goes to prison, comes out, and Secretary of State says, well, you've not been law-abiding, so you're not social and culturally integrated. That happens often. And what the Secretary of State will do is rely on the case of Bimbuga in the Court of Appeal. I've had that done in court. Again, Secretary of State represented by counsel also relied on Bimbuga. But what you have to do is to, I said don't get bullied. I meant that sort of as a joke, but stand your ground, because the authority is CI Nigeria, which really is worth a read. It explores everything. I've put some of the most important aspects of that here in this slide. CI Nigeria also considers Bimbuga. So any suggestion that somehow Bimbuga should take precedent over CI Nigeria so far as social and cultural integration is concerned, I would encourage you to persuade the court otherwise, or the Home Office otherwise. Bimbuga was a case that essentially the first year tribunal had said that, and the appellant in that case was part of a criminal gang in London. And the first year tribunal judge said that, well, that is an unsavory part of UK culture, which he is part of, the appellant. So he is, in that respect, social and culture integrated. And Bimbuga said, that's rubbish. Well, nobody's really surprised by that. But that's the authority for Bimbuga. And that's a very specific context in which Bimbuga said what it said about social and culture integration. Again, CI Nigeria is the authority for culture and social integration. You need to fight these cases on these points. Very briefly, basically, CI Nigeria says that the point of the culture and social integration is to show that the appellant in your case has established a private life, enough of a private life to raise an Article 8. So that's really what you're looking at. And that, in other words, means it's not a particularly high threshold social and cultural integration. I've had Home Office representatives or in refusal letters see that they suggest that because your client didn't contribute to society, they're not social and culturally integrated. Again, nonsense. It's not such a high test. Another important factor, paragraph 79, is that you don't look at, this is sort of related to paragraph 57, you don't look at the public interest, strength in public interest in deportation, or the interference. What you're really looking at is the engagement of private life. And really the crux of CI Nigeria is here. The judge should simply have asked whether, having regard to his upbringing, education, employment history, history of criminal offending and imprisonment, relationships with family and friends, lifestyle, and any other relevant factors, CI was at the time of the hearing. Again, this is very important. You're looking at the circumstances at the date of the hearing. Even if your client has been in prison for 6 years, if the appeal hearing is 5 years after he's been released, by that time, he may, again, nevertheless, be socially and culturally integrated. If he's reestablished contact with his family, if he has, I'm saying he because CI Nigeria was a he, if he has a wife or children or partnered children, if he started work, these are the things that you would consider at the date of the hearing. So you look at whether the appellant at the time of the hearing was social and culturally integrated in the UK. The judge should not, as he appears to have done, have treated C as offending and imprisonment as having severed his social and cultural ties with the UK through its very, through its very nature, irrespective of the actual effect on CI's relationships and affiliations. And this is very important because what the Court of Appeal is saying here is that you don't look at the criminal offending in and of itself to say, because you've committed offenses, you're not social and culturally integrated. That is a wrong approach legally. If that was correct, most people wouldn't satisfy this requirement. You're looking at the effect of criminality and what that had on their social relationships and affiliations. And the Court of Appeal very helpfully referred to a case called AM Somalia as a comparator. We have to be careful about comparing facts, but it's a very helpful case to even have it in the back of your mind in case this comes up. AM Somalia was an individual who had come to the UK from Somalia at age 12, lived in the UK for 30 years, had attended secondary school, had several jobs, married, and had 3 daughters. So at this point, you would say, gosh, this person is so social and culturally integrated. There is no way anybody could find that this person isn't. But then at around age 25, his marriage broke down and he moved into a hostel. He lost contact with his family and essentially became addicted to alcohol and so forth. And then over a decade, started committing a bunch of offenses. And as a result, by the time of the hearing, he was homeless, he didn't have a job, he knew very few people, had no contact with any member of his family. I think he didn't even have a relationship with his children by that time. And he had no evidence that he had any friends or other interactions of private life. So that's an extreme example, but it shows to you how the effect of drink-related offending eroded his relationships with other people, his housing situation, his job, employment, and so forth. It wasn't just the fact, it wasn't the offending in and of itself that was the problem. It was the effect of the offending that eroded the social and cultural ties that he previously enjoyed. So that's the important point to bear in mind. That's social and cultural integration. Moving on. The final question, again, remember this is conjunctive, so you have to satisfy all 3 provisions here. Very significant obstacles to C's integration into a country to which C is proposed to be deported. By now, you'll be familiar with the case of Camara, which says that integration is a broad evaluative concept. It's not confined to mere ability to find a job or sustain life. It's about being accepted as one, as enough of an insider by the time after some certain time has passed. So just because you're able to get a job, it doesn't mean that you're going to be socially and culturally, it doesn't mean that you're not going to face very significant obstacles to integration. I'm not going to spend too much time on this because this really speaks for itself. Camara is authority. It was approved by the Supreme Court in SC Jamaica. Again, if you're dealing with very significant obstacles, this is why I say, even if you don't meet the initial provision, the sub-provision of exception 1, my highlighting skills are terrible at the moment, apologies. Even if you don't satisfy this, still address this, because this is very important. If your client is still going to face very significant obstacles to integration, but he's not been in the UK for more than half of his life, that still can be given very significant weight in the proportionality assessment of very compelling circumstances under section 117C. So that's a private life provision. If you satisfy it and your sentence is less than 4 years, all good. Your appeal should be allowed. If you don't satisfy it, or if your sentence is more than 4 years, we have to consider other provisions as well. The second provision is exception 2, and this is the family life provision. I'm not going to spend too much on this either. This is sort of intended a broad overview. I've decided to keep it quite broad so we can cover as much as possible rather than a super in-depth theoretical exercise. So exception 2, family life. Exception 2 applies where C has a genuine subsisting relationship with a qualifying partner or a genuine subsisting parental relationship with a qualifying child. And that's conjunctive. the effect of C's deportation on the partner or child would be unduly harsh. So unduly harsh. I mean, I'm not going to go through what genuine subsisting is, because we have had too many cases about this, from Gaudi to RK in the upper tribunal, to AB Jamaica in the Court of Appeal. So I'm not going to deal with genuine subsisting. I'm going to deal with what's most likely going to cause more significant difficulties, which is the question of unduly harsh. KO Nigeria, you will know, is the Supreme Court authority which finally found that you don't look at the seriousness of the offense when you're considering unduly harsh. That KO Nigeria considered the circumstances of a child, but I imagine, my guess is that it also applies to the partner. I think that's how it's been interpreted and applied. Certainly in my experience, that's how it's been done. So when you look at unduly harsh, you only look at unduly harsh. It doesn't matter how serious, as long as the sentence is less than 4 years, it doesn't matter if it's shoplifting or armed robbery. If it's unduly harsh on your child and the sentence is less than 4 years, then the appeal should be allowed if it's unduly harsh. In HA Iraq, when considering unduly harsh, this has caused the courts also some difficulties, because the question was, when you're looking at unduly harsh, KO Nigeria suggested, Lord Carnwath suggested, that it has to be something more, the level of harshness has to be more than something people ordinarily would expect to experience in a deportation appeal. And it was interpreted previously that suggested that there was some notional comparator against which you consider the undue harshness. So for example, you would say, well, for every deportation is harsh for every child. So then you have to somehow show that it goes beyond what every other child would experience. But finally, the Supreme Court in HA Iraq held that no, that's incorrect. You look at only the circumstances of the child. You have to look at the child's dependency level. For example, the extent to which that child is dependent on the parent will determine how harsh it would be, how harsh deportation would be. I'm going to go through the helpful bits of HA Iraq in a second. The most authoritative test is MK. Again, MK is the one that you should need to consider. It's essentially more than uncomfortable, inconvenient, or undesirable. So that, just bear that in mind. Another thing to bear in mind in unduly harsh is delay. Delay is something that I am obsessed with. I've been arguing this in the upper tribunal for at least a couple of years now. Actually, there might be a case coming out shortly in the upper tribunal dealing with the question of delay in deportation. I've done a whole seminar on it, so I'm not going to belabor that. But essentially, one point that you need to bear in mind is delay. Even if there's egregious delay, let's say the Secretary of State doesn't take a decision to deport your client for 15 years. According to the Court of Appeal in Reed, that doesn't affect the question of unduly harsh on the qualifying child. I'm not necessarily convinced that that's correct, but for now, that's I think at the moment is ratio. So even if there's delay, that doesn't affect the unduly harsh aspect of it, but it will, of course, affect the very compelling circumstances, which I'm going to touch upon in a moment. A few more bits, helpful bits from HA Iraq in the Court of Appeal. These findings haven't been disturbed by the Supreme Court, and they're extremely helpful. I still continue to refer to these bits in these passages, I should say, rather than bits. These passages in when I do deportation appeals. The first is paragraph 56. There's no reason in principle why cases of undue harshness may not occur quite commonly. And that really highlights to us that although it is a high test, it doesn't mean that it has to be extremely rare. Okay, you might want to bring this to the forefront of the judge's mind or the Home Office's mind when you're making representation, so that it's quite easy for us to think exceptional circumstances in our mind, but it doesn't have to be. if it's unduly harsh on the child, it's unduly harsh on the child. It's an elevated test, but it's far less elevated than very compelling circumstances. So it can occur quite commonly. Commonly. Some of the factors you consider: the child's age, whether the parents live with them or the parent, degree of the child's emotional dependence on the parent. This is going to be extremely important. You might want to get letters from the school. You might want to get letters from social services, from independent social worker to sort of assess the dependency of the child on the parent. Often what's helpful is if the parent has been incarcerated, you will have a mini test run, if you will, although it's not comparable at all because there's visiting rights and so forth, and it's a defined period, still a test run of what it would be like. And the way in which that child, the qualifying child, reacted and behaved as a result of incarceration could be a very, very helpful insight into how it's going to affect the child if the parent is deported, what's most likely going to be for a permanent period, or at least for 10 years. The financial consequences of a deportation and the emotional and financial availability from the remaining parent and other family members, and also the practicality of maintaining a relationship with the deported parent. These are all factors that you should take into account. You should address in your representations, again, written or orally. These are very helpful factors that the court has identified. The court has also cautioned against comparing two different cases. We used to have cases, I certainly used to have presenting officers and counsel say, well, look at this Court of Appeal case, or look at this upper tribunal case. In this case, X and Y, there was X, Y, Z factors, and the appeal was still dismissed. So this case should be dismissed. You refer to, if the Home Office makes an argument, you refer to paragraph 129 and say, no, don't compare cases. No two cases are in truth substantially similar because no two child is the same. So bear that in mind. Again, this is also, I find this, gosh, my highlighting skills are not improving. This is a sentiment and guidance that is, again, very helpful. For some children, deportation of a largely absent parent may be a matter of little or no significance. For others, the deportation of a close caregiver parent, where face-to-face contact cannot continue, may be akin to bereavement. And again, that's highlighting the fact that each child relates to their parent extremely differently. If, for example, a child is 4, 5, 6, or even that age, it may be that deportation would be more akin to bereavement. They can't really understand the nuances of a long distance relationship, even if one is going to be maintained through modern means of communication. So you really want to hone in and focus on the dependency and the level of emotional dependency the child and the parent has to deport the foreign national offender. And finally, paragraph 159 essentially says, I'm not going to read the whole thing, essentially it says that you can't hold emotional harm as more inferior to physical harm. It's quite easy because physical harm is more palpable. You can see physical harm. You can't really see emotional harm. It's easy to give physical harm more weight. But the court has said that's wrong. Emotional harm is as important as physical harm, and don't undermine the importance of protecting children from emotional harm. So there's no reason in principle why, for example, if the child is going to be particularly distressed, that's not already unduly harsh. I think that covers undue harshness. Hopefully, I've covered it as to the best of my abilities. I have within limited time that I have. If you want to discuss more with me, let me know. I could talk about this stuff for hours, but nobody else wants to. So section 117C6, very compelling circumstances. So this is essentially a catch-all provision. If you don't come in within exception 1 or 2, one thing I should say in relation to exception 2 is you have to consider the go scenario and the stay scenario, meaning, is it unduly harsh if your child goes with you to the deported location, Or is it unduly harsh for the child to remain in the UK, so stay in the UK without you? You have to consider both scenarios. You can't just consider one. That's very important. Sometimes the Home Office will concede that it will be unduly harsh for the child to leave the UK, so then you have to only consider the stay scenario, so it's staying in the UK without you. Right, if you don't satisfy the exceptions, then you come under very compelling circumstances. This is a very demanding test, and it's a high threshold. I don't need to remind you that. We all know. But this is where you're going to really raise all the important, compassionate, compelling circumstances of your case that may not come under exception 1 and exception 2. And you will want to use these factors as a sort of like a guiding guardrail to try to focus your submissions on these points, because these are very helpful factors that any first-year tribunal or upper tribunal judge would be considering for themselves. So you might as well address them. But in the end, it's a proportionality assessment. On the one hand, you consider the very, very significant public interest in deporting foreign nationals. And on the other hand, you're considering all the compelling and compassionate circumstances surrounding your client's case and your client's family's case, and it's a balancing exercise. And if it outweighs it, then, if it outweighs a very significant public interest in deportation, then there are very compelling circumstances that are over and above those described in exceptions 1 and 2. And these are the factors. Again, I'm not going to go through them here, but many of it you will have to address. I'm going to address 3 of them here. The first one is the seriousness of the offense. You have to address this now more fully. Before, essentially, you would just look at the length of sentence, the sentence imposed by the criminal courts, because that would indicate the seriousness of the offense. And that's still the case following H.A. Iraq in the Supreme Court. But now there's a bit more nuance to it. So the Supreme Court has said that you can look at you can look at other circumstances that influenced the sentence, although unrelated to the seriousness of the offense. So, for example, if your client was given credit for a guilty plea, that could be a factor that the court takes into account and says, even though the sentence, let's say for argument's sake, the sentence was 3 years, but because of a guilty plea, it was reduced to 2 years. The first-year tribunal can say, actually, I'm going to take this as serious as 3 years because the only reason the appellant was given 2 years was because of a guilty plea, which doesn't affect the seriousness of the offense. The Supreme Court said guilty plea is relevant, but not to seriousness of the offense, but more to rehabilitation and to risk of reoffending, not to the seriousness of the offense. And also nature and circumstances of the offense can also be taken into account, but you have to be careful that the first-year tribunal doesn't double count it, because often aggravating features of a crime will have been taken into account by the criminal courts in sentencing. So, for example, if there was additional element of violence or dishonesty or repeated offending, etc., that will have been taken into account by the criminal court. So make sure that you don't double count that, or make sure that the court doesn't double count that, rather. For this, the nature and circumstance of the offense, often you won't have much information, but what you will have, and hopefully you will have, is the Oasis report. And the Oasis report is extremely helpful because this explains the background to the offense in considerable detail. And you should really, I encourage you very strongly to read the Oasis report, because you will find things that your client may have not told you before, and the Home Office might pick up on it, or the judge might pick up on it, and the last thing you want to do is somebody in court pointing out something that you've not considered previously. The OASIS report is very helpful. There may be unhelpful things in there. Take your client's instructions on that and put it in the statement. Address it head on. Don't count on people not reading the OASIS report, because it's the most obvious place to read. And it will give you a very, very good flavor of how serious the offense is. And for example, your client may have told the probation officer and offending manager that actually his offense was committed as a result of, I don't know, past abuse or very difficult upbringing or addiction or some sort. And that's very helpful, because then you can explain the circumstances of the offense and why that reduces the culpability or why that reduces the seriousness of the offense. Another thing to consider is delay. Again, don't get me started on delay, because I could speak for hours about this. As I said, there is potentially an upper tribunal case of mine that is going to be reported on the question of delay. For present purposes, what I can say is that you should consider the case of MNT Colombia. I've done a whole seminar on this, actually. It might even be on our Goldsmiths Chambers YouTube page. Essentially, if there is a delay in taking a decision to deport your client after your client's lost an appeal, or even after release without any action, then that delay can very critically reduce the public interest in deporting your client, because it affects all three elements of the public interest in deportation. And so really you want to consider if there is an element of delay or not. If you want to speak to me about delay, again, email me. I'm happy to speak to you about delay and if there is a delay. Okay. Finally, rehabilitation. This is also a factor that you want to really focus on, because it's going to be an important, it's a factor that everybody's concerned about, rightfully. Obviously, you want to make sure that whoever is going to stay in the UK is not going to continue to commit offenses, and so the judge considering the case or the Home Office will really want to make sure that that's addressed. What the Supreme Court in HA Iraq has said is that there is a difference between positive rehabilitation and what I'm going to call negative rehabilitation, which is just evidence of non-offending, the fact that no further offenses have been committed. If that's the only evidence you have, the Supreme Court has said that that is negative rehabilitation, meaning rehabilitation without any positive action. And so it will be given little or no material weight. Am I highlighting? Little or no material weight. Whereas if it's positive rehabilitation, where there is evidence of action taken by the appellant to reduce the risk of further reoffending, then that may have some weight to reduce the public interest. How do you do that? Detailed witness statements, really expressing genuine remorse is helpful. Accepting your offense is obviously helpful in immigration courts. Demonstrating insight into your offending behavior is a very good way to demonstrate an action taken by the appellant to reduce the risk of reoffending. So, for example, if your client decided to go for therapy and address some of the offending behaviors, that's a very good example. Obviously, courses in prison, but everybody's taking courses in prison, to be honest with you. So, volunteering and so forth as well. Those are helpful things, but I do think genuinely a detailed statement which shows a level of introspection and insight into your own offending behavior and the steps you have taken. If that is set out in the witness statement, I feel, my view is that that would constitute positive rehabilitation. One thing that I've said here, is that the court has said that rehabilitation can't be given decisive weight, because public interest consists of three elements, right? protection of the public from further offending, deterrence and expression of public concern at the offense committed. And rehabilitation only affects the protection of the public element. The courts have said that rehabilitation doesn't affect the policy reasons of deportation, one of which is deterrence and the other is expression of public concern. So even if your client there's zero chance of your client ever reoffending again, that's not decisive because there is still the deterrent effect of deportation and the expression of public concern at the offense committed that remains. That may be reduced by other factors, but the point is that don't rely on rehabilitation alone. That's why the extent to which you satisfy exception 2, exception 1, the extent to which there's been a delay, the seriousness of the offense, the effect of deportation on your other family members and so forth, all of that has to be prayed in aid. Don't just rely on rehabilitation. That being said, if there is egregious delay or considerable passage of time, then arguably, certainly it is something that I am seeking to argue in the Court of Appeal. We're seeking permission to appeal to the Court of Appeal in one of the cases concerning this, where there was, I think it was like 20 years had passed since the offense was committed. And we are seeking to suggest, or seeking to argue in the Court of Appeal, the UT didn't agree with us, that in those circumstances, where there's been 20 years, then very significant weight can be given to rehabilitation, not just some weight. So look at when the offense was committed, look at when your client was released from prison, and look at their conduct thereafter. And then pray that all in aid for rehabilitation. Obviously, it goes without saying, look at the OASIS report, because that will say what the likelihood of reoffending is. So you're going to have to look at that. Final thoughts. So that really covers, this is my final thoughts, but I'm going to leave some time for Q&A if there is time. I see that there's some chats and I've not looked at it yet, but yeah, deportation appeals are becoming harder and harder to win, but they're definitely winnable. Every time I win, we're all surprised. Not when I win. I mean, when every time, not every time I win, everybody's surprised. Just every time a case is won, it's really delightful, obviously, because they're so difficult to win. In many cases, Secretary of State will appeal further. I've had many cases where the Secretary of State has decided not to appeal. Recently, for example, I had an appeal in the UT where the client had been convicted for an offense. He was sentenced to 8 years imprisonment. We won in the UT, and the Secretary of State didn't didn't appeal further to the Court of Appeal. Lately, we had a 13-year sentence where we won. That one, I'm fairly certain it's going to go to the upper tribunal. But these are winnable, and the reason they're winnable, I find, is if the bundle is prepared very thoroughly. The witness statements are thorough, are detailed, are really drawing out all the compelling circumstances. And you know, you have family members coming to court, you have letters of support, you have good evidence of rehabilitation, positive rehabilitation, and so forth. If that's done, they are winnable. Don't feel like deportation appeals are not winnable. Certainly at Goldsmith Chambers, they're being won. So hope you keep up the good fight, all of you. Yeah, so thank you very much for tuning in, joining. That concludes my my section. I think the end of the day. I'm happy to give some time for some questions if there are any, and if they're not too complicated.
Well, thank you very much indeed, Lawrence. I absolutely agree with you. It's all in the preparation. If you really prepare well for a deportation appeal, it is winnable. Mind you, the same could be said for anything, really. It's the preparation that goes into it that is the difference between winning and losing, really. But anyway, let's see if there are any questions for you in the Q&A. I was just having a look myself. Now, at the bottom, there's something about British nationality. 30 questions. Oh, I can't seem to get any further down, scrolling down. So there may not be any about deportation, but then
Brilliant. I'm happy to be off the hook.
you were covering it very thoroughly, Lawrence. So it looks as if you are off the hook. And as you say, that was the last of our talks today. And thank you to all the speakers who gave us very useful briefings on their subjects. And thank you to the audience who I see have mostly stayed till the end. So if you managed to stay all this time, thank you very much indeed for your patience and attendance. So with that, on behalf of all of us here who are the speakers, we'll say goodbye and hope to see you at the next training session. So bye-bye, everyone.